Sound check. Sound check. 1, 2.
clerk of court will please call the matter at hand.
GR numbers 217-126 to 27, Honorable Conchita Carpio-Morales, in her capacity as Ombudsman, versus Court of Appeals, 6th Division, and Jejomar Erwin S. Binay Jr. Appearing as counsel for petitioners, Honorable Conchita Carpio-Morales as Ombudsman are the following: Acting Solicitor General Florin T. ASG Hermes L. Ocampo, Senior State Solicitor Rigodon, Private Respondent Jejomar Erwin S. Binay Jr. are the following: Certeza, Sarmiento II,
For both parties will please remain standing. You are required.
Your Honor, for the petitioner ombudsman, I will be arguing.
For respondent Mayor Jejomar Binay Jr. Erwin.
Good afternoon, Madam Justice. Insofar as respondents are concerned, we would ask the court's indulgence if we are to be allowed to have two counsels to face to the interpellation, and we will divide it in accordance with the issues as laid down in the advisory of this honorable court, if it will be allowed, Your Honors.
And who will be arguing?
I will be arguing on items A, C, D, E, F, and H, while Attorney Coronel will be answering the interpellation with regards to issues B, G, I, J, and K as of this honorable court.
Okay. You're allowed to have two counsel argue the same.
Thank you very much, Your Honor.
So may I now request that the Acting Solicitor General, Mr. Florin Hilbay, kindly please take the podium while the rest can take their seat. You have all been advised about the order of the proceedings herein. Interpellations. Justice Ardileza, please.
Good afternoon, Mr. Solicitor General.
Good afternoon, Your Honor.
This is the first time the Ombudsman has invoked Section 14 of the Ombudsman Act.
So far as I know, with specific particularity, yes, Your Honor.
Yes. And for the guidance of this court, we would like you to confirm the following. First, it is your position that only the Supreme Court can issue an injunctive writ on investigations being conducted by the Office of the Ombudsman.
Our position, Your Honor, is that RA 6770, Section 14, allows for the possibility of injunctive writs whenever there is a prima facie.
Is flashed on the screen alongside Section 14 of the Ombudsman Act. Now, I call your attention, Mr. Solgen, to the text of RA 8975. It says, where the Congress in the law expressly said, and I quote, except the Supreme Court, close quote. Now, the first paragraph of Section 14 does not say except the Supreme Court. What is the support for your conclusion that Congress intended to remove the original Rule 65 jurisdiction of the Court of Appeals in Section 14?
Okay. Your Honor, the Constitution. The Constitution is read into every statute that is passed by Congress. Our position, Your Honor, is that while the Court of Appeals under BP 129 has general jurisdiction, That general jurisdiction, whether or not to issue, that general original jurisdiction, which includes the authority to issue ancillary writs, has been substantially and substantively limited by Section 14.
Do you have legislative history of the Ombudsman Act to support your argument?
Your Honor, we have the records of the deliberations. We looked at Section 14, and there's not a lot of discussion with respect to any particular intent. But our position, Your Honor, is that Section 14 is palpably clear and did not require us to look into any specific intent on the part of the Congress when it drafted Section 14.
Can we agree then that, in fact, the legislative record does not contain any line? Is this carve out an amendment or a repeal of BP 129?
Your Honor, it's simply lex specialis, meaning that with respect to all other cases, with respect to all other instances where the Court of Appeals may exercise its jurisdiction, original jurisdiction for certiorari, prohibition, and mandamus, that power is untouched. But with respect to the particular power of the Court of Appeals to issue temporary restraining orders, Section 14 will have to apply because that is the specific rule carved out by the Congress.
How do you reconcile your argument with the rule that implied amendments or repeals are not favored?
Your Honor, that is true. In fact, our position is that this is a specific amendment of the power to the power of the Court of Appeals with respect to the power to issue temporary restraining order or any writ of injunction in respect of any investigation being conducted by the Office of the Ombudsman. And as we have argued in our paper, Your Honor, this is not novel, in fact. The Congress has done this for national government infrastructure projects. And so, given the plenary constitutional authority of the Congress to grant, revise, amend the jurisdiction of the various courts other than the Supreme Court, there can be no constitutional objection to that limited jurisdiction of the Court of Appeals in relation to any investigation being conducted by the Office of the Ombudsman.
Thank you. Now, we note again, as we said a while ago, that this seems to be the first time that the Ombudsman has advanced an interpretation that Section 14 withdraws from the Court of Appeals its original Rule 65 jurisdiction. And we ask you the following questions. It took the Office of the Ombudsman 26 years from 1989, which is the date of the enactment of the Ombudsman law, before it advanced this interpretation you are now arguing. Does this undermine or does this strengthen your argument about the intent of Congress on Section 14?
No, Your Honor, no effect whatsoever. In fact, I do not know whether or not this is the first time that this was raised. What I said earlier, Your Honor, is that this is the first case, right, that has garnered sufficient attention with respect in particular to the power of the Ombudsman under Section 14. If you look at the cases, you will see citations of Section 14 with respect to petitions for injunction against the Office of the Ombudsman. What we can confirm for sure, Your Honor, is that this is the first case where, in particular, this particular power, this specific power is in issue. In fact, almost the only issue in this case.
Thank you. Now, we note from our own reading of the cases that as early as 2001, we said in Barata, which we reiterated in Dagan, that Rule 65 petitions against the orders of the Office of the Ombudsman should go to the Court of Appeals. If, as you claim, Congress had intended to withdraw the Court of Appeals jurisdiction over Rule 65 petitions, then why do you think Congress did not insist on this interpretation of yours by, for example, enacting a law specifically withdrawing from the Court of Appeals its Rule 65 jurisdiction?
Your Honor, it is entirely difficult to predict, contingent facts that might arise out of a litigation. As I have said, Your Honor, what we can know for sure is that this is the first case where, in particular, this power is being invoked by the Office of the Ombudsman. I am quite sure that in many cases involving petitions for certiorari before the Court of Appeals, this power has previously been invoked. Right? If I may add as well, Your Honor, our argument is very specific. Right? Regardless of the power of the Court of Appeals over certiorari, what is very clear under Section 14 of the law is that Congress has denied it the power to issue an injunction. The power to issue an injunction. And with respect to that denial of the power to issue any writ of injunction, there can be no doubt. Again, Your Honor, I refer you to RA 8975, where the Congress has also denied to statutory courts the power to issue any TRO, writ of preliminary injunction, given the clear policy to promote economic development. In the same way, with respect to Section 14 of RA 6770, the goal is to ensure that the Office of the Ombudsman can proceed with its investigation consistent with its constitutional authority and the general leeway it needs to have when it wants to conduct its investigation without any undue interference from any statutory court.
Thank you. We now leave Section 14 for the moment and go now to your argument about the power of Congress to apportion the jurisdiction of the courts. You cite the power of Congress under Section 2, Article 8 of the Constitution. And that's on the screen. My question is, are there constitutional limitations to this power? And are there constitutional limitations to this power, if any? And if so, what do you think are these limitations?
Thank you, Your Honor. The specific constitutional limitation to Article 8, Section 2 is in the law itself, Your Honor. And that is that regardless of the extent of the plenary power of Congress to create courts by defining, apportioning, and prescribing statutory courts' jurisdiction, it has no constitutional authority to touch the power of the Supreme Court under Section 5. I suppose as well, Your Honor, that to the extent that the Equal Protection Clause, the Due Process Clause, and other general principles of constitutional law may apply to all the powers of Congress, those general restrictions may also be implied against, with respect, Your Honor, to the Article 8, Section 2 powers of the Supreme Court.
Thank you. So you have mentioned already the limitation under Section 2 that the Congress may not deprive the Supreme Court of its jurisdiction over cases enumerated in Section 5 of the same provision.
Yes, sir.
Please check. Do you agree?
I agree, Your Honor.
That is one limitation.
Yes, Your Honor.
We call your attention to Section 30 of Article 6 of the Constitution. Section 30 says, no law shall be passed increasing the appellate jurisdiction of the Supreme Court as provided in this Constitution without its advice and concurrence.
Yes, Your Honor.
So, is this also another limitation to the power of the Congress to apportion the jurisdiction?
Your Honor, not with respect to Section 2. Article 8, Section 2, specific limitation refers to the original jurisdiction of the Supreme Court. Now, the Court of Appeals has the power to increase the appellate jurisdiction of the Supreme Court, except that it has to do it consistent with Article 6, Section 30.
Thank you. Professor, no, I'm not yet through. Professor, I'm not yet through, Chief CJ. Professor Lawrence Tribe of Harvard Law, in his treatise on constitutional law, opines that there are twin limitations to the power of Congress to apportion. These limitations he calls the intrinsic, and the other he calls the extrinsic. The intrinsic limitations are those contained in the constitutional provisions on apportionment. Just like, for example, if it's in the Philippines, Congress has the right to apportion, but may not increase the appellate jurisdiction of the court without its consent. It can apportion, but it cannot deprive the court of its jurisdiction over the case that is stated in the Constitution. So Tribe calls these intrinsic limitations found in the Constitution itself.
Yes, Your Honor.
He further opines that there are the so-called also extrinsic limitations, meaning outside of the provisions on the power to apportion. And the function of extrinsic limitations are to protect the exercise of constitutional rights from what are, in American constitutional law, called jurisdiction stripping,
Yes.
meaning you strip the courts of jurisdiction, or in the language of Professor Tribe, in an article he had, what he calls jurisdictional gerrymandering.
Yes, sir.
Now, we suggest to you that arguably under the Philippine Constitution, intrinsic limitations take the form of Section 30 of Article 6 and Article 2 of Article 8. Now, we would, however, want to raise with you and seek your opinion on whether or not under Philippine constitutional law there are what Professor Tribe calls extrinsic limitations to the power of Congress. There are two possible extrinsic limitations, arguable limitations, which we would like to hear from you, your views. First, there is a bundle of constitutional values identified in Fabian. Specifically, 1, that this court is not a trier of fact. 2, that factual controversies are usually involved in administrative disciplinary actions, just like those coming, for example, from the Civil Service Commission. Three, that Rule 43 of the Rules of Court was precisely formulated and adopted to provide for a uniform rule of appellate procedure for quasi-judicial agencies. And fourth, that elevating the resolution of these matters directly to this court will unnecessarily burden this court. These values have guided this court to our mind for 17 years, since 1998, in its disposition of administrative cases under the Ombudsman Act. This bundle of values arguably reflects this court's view of its judicial power. In a way, it is distilled and articulated under the doctrine of hierarchy of courts. Thus, this view by this court of its judicial power operate as an extrinsic limitation to the conceded power of the Congress to apportion the jurisdiction of the various courts. And before you answer the question, is this view by this court of its judicial power just a matter of policy? Or does it involve issues of separation of powers and checks and balances which this court is constitutionally bound to defend? In other words, Mr. Solgen, can the Congress reverse a doctrine by the expedient of rearranging the jurisdiction of this court? For example, in the case of St. Martin, this court held that Rule 65 petitions in labor cases of the NLRC must be filed with the Court of Appeals in accordance, among others, but chiefly, the doctrine of hierarchy of courts. Can Congress now set aside this doctrine in St. Martin simply by enacting a law withdrawing from the Court of Appeals jurisdiction over Rule 65 petitions of the NLRC? Will this not reverse a decision of this court?
Okay, no.
You may answer now, Mr. Solicitor General.
Thank you, Mr. Justice Francis Hardalesa. Well, if I may quote from another Harvard man, there can be no legal right against an authority that makes a law on which the right depends.
And who is this? And who is this?
I think that is Holmes, Your Honor. I think, Your Honor, that we can disaggregate, the statements that you have made. With respect to the decision in Fabian, what the court did in Fabian is to craft the remedy with respect to decisions of the Office of the Ombudsman. And so in cases where there is a decision of the Office of the Ombudsman, that decision will have to go to the Court of Appeals under Rule 43, not under Rule 45 as was stated in Section 7 of the Ombudsman Law. And the justification for that is because, as Justice Regalado mentioned in Fabian versus Desierto, the court's consent and advice was not secured in the passage of Section 27. But that is with respect to appeals, Your Honor. We go back to what I stated before, that jurisdiction is a matter of law. With respect to the Court of Appeals, the Congress, as I have said, Your Honor, has full constitutional authority, right, to define, prescribe, and apportion the jurisdiction of the various court. There is no doubt, Your Honor, that the Court of Appeals is a statutory court. And so, can the Court of Appeals, can Congress deny entirely both the power of the Court of Appeals to have original jurisdiction over petitions for certiorari, as well as the power to issue ancillary writs and provisional remedies? Well, of course, given that the Court of Appeals is a statutory court, can Congress, instead of just granting the power of judicial review, deny the by giving the power original jurisdiction to hear petitions for certiorari, deny the power to issue ancillary writs and provisional remedies? Well, of course, Your Honor. And again, the example is RA 8975. And so, Your Honor, again, consistent with our short paper that we submitted yesterday, the jurisdiction of the Supreme Court under Article 8, Section 5.1 is untouched. The power also of the court to create remedies pursuant to its rulemaking powers is also untouched, and therefore consistent with the decision in Marty, consistent with the decision in Fabian versus Desierto, the court can say, well, instead of going straight to the Supreme Court, we decide as a matter of policy that you go to the Court of Appeals by Rule 43 in cases of appeals from decision of the Office of the Ombudsman. But is that incompatible with the statutory policy in RA 6770, Section 14, which deals narrowly with respect to the power of the Court of Appeals to issue injunctions, injunctive writs, such as a temporary restraining order or a writ of preliminary injunction? No, Your Honor, we submit there is no such incompatibility. In fact, everything is fully logical and comprehensively answered, by simply basing what the court can do on the Constitution and what Congress can do under Section 2 of Article 8. Thank you.
I just have one more question bearing on the matter of whether the power of the Congress to apportion the jurisdiction of the other courts is subject to extrinsic limitations. And the question is, would you consider the Equal Protection Clause as also arguably an extrinsic limitation to the power of Congress to apportion the jurisdiction of the various courts? Now, under your interpretation of Section 14, Rule 65 petitions involving orders of the Ombudsman may only be brought before this court. However, Rule 65 petitions of orders of all other quasi-judicial agencies, including, for example, the Office of the President, which is a co-equal branch of government, and the Civil Service Commission, which is also an independent constitutional body, are first brought to the Court of Appeals. So my question is, your position, does it implicate equal protection?
Your Honor, with respect to the theoretical question whether or not the Equal Protection Clause will affect the plenary power of the Congress, the answer, Your Honor, is yes. And if I may provide an example, suppose the Congress passes a statute that says that the Court of Appeals would have certiorari powers with respect to petitions filed by men, but not by women. Then that would clearly be a violation of the Equal Protection Clause, because this is a case where the Congress has provided a statutory remedy by way of a petition for certiorari for males, but has denied entirely the power to seek a remedy before the Court of Appeals simply because they happen to be females. But, Your Honor, with respect to, again, Rule 43, we would like to emphasize that the ruling in Fabian refers to appeals from decisions, Your Honor. Appeals from decisions. And therefore, it does not implicate petitions for certiorari with respect to interlocutory orders filed against the office of the Ombudsman. And again, Your Honor, in fact, Fabian equalizes, right, the system with respect to quasi-judicial agencies, such that when it comes to appeals from decisions of the OP and other quasi-judicial agencies, petitions, appeals from decisions of the Office of the Ombudsman would have to go to the Court of Appeals via Rule 43. But again, Your Honor, that is a separate question whether or not interlocutory orders by the Office of the Ombudsman can be subjected to a writ of preliminary injunction. And again, Your Honor, our answer is rather simple. Does the Court of Appeals have statutory authority from Congress, right, to issue writs of preliminary injunction on investigations by the Office of the Ombudsman? In particular, in this case, preventive suspension. The answer is rather straightforward, and it is no, because no one can find any statutory authority from Congress granting the Court of Appeals the power to issue a TRO or a writ of preliminary injunction. In fact, there is an express prohibition against any court, meaning any statutory court, issuing a writ of injunction against an investigation being conducted by the OMB.
Thank you, Mr. Soljan. Now, we move to another of your arguments. You have an argument about residual jurisdiction
Yes.
under Section 14, right?
Yes, Your Honor.
Section 14 says that there may be a writ of injunction may be allowed when there is prima facie evidence that the subject matter of the investigation is outside the jurisdiction of the Office of the Ombudsman. And it is your position that the coverage of this exception, that is, matters outside the jurisdiction, are 3: impeachable officers, members of Congress, and the judiciary. Right? This is what you call residual jurisdiction under Section 14.
Yes, Your Honor.
Now,
That is quite true.
We would like you to consider whether there is one more residual jurisdiction under Section 14. 14 states, again in part, no writ of injunction shall be issued by any court to delay an investigation being conducted by the Ombudsman. Therefore, under your theory of residual jurisdiction, arguably, if a writ of injunction does not delay an investigation, do you mean that the Court of Appeals retains its jurisdiction?
Your Honor, I think a writ of injunction, by definition, is an injunction that delays the investigation of the Office of the Ombudsman.
I am down to my last 3 questions, Mr. Soljan. Has the Court of Appeals given due course to the petition for contempt?
I am not aware, Your Honor, of any resolution from the Court of Appeals. What I know for sure, Your Honor, is that the Office of the Ombudsman has been required to comment.
Have you filed your comment?
Yes, Your Honor.
Isn't your comment the plain, speedy, and adequate remedy against the petition for contempt?
With respect to the petition for contempt, Your Honor, again, our arguments are jurisdictional, and therefore, we believe that given that we have already raised the matter of the jurisdiction of the Court of Appeals to issue the writ of the TRO or the writ of preliminary injunction anyway, and that the issuance of these resolutions by the Court of Appeals are so intertwined with the facts constituting the petition for indirect contempt. Therefore, we consider the petition questioning the jurisdiction of the Court of Appeals to hear and decide the petition for indirect contempt as the plain and speedy remedy under the circumstances of this case, Your Honor.
Thank you, Mr. Solicitor General. I have no further questions.
Thank you, Mr. Justice Francis Ordales.
Mr. Justice Carpio.
Good afternoon, Mr. Solicitor General.
Good afternoon, Mr. Justice Carpio.
Let's go to some basic facts because I think these basic facts will guide us in resolving this case. Okay? You will recall that the Ombudsman created a special panel of investigators to conduct fact-finding or case build-up against Makati City Hall officials, including the incumbent Mayor Binay Jr. Is that correct?
Yes, Your Honor.
The special panel of investigators submitted its investigation report to the Ombudsman, and the investigation report concluded that a preliminary investigation and an administrative adjudication should be conducted. These are two separate proceedings: preliminary investigation and administrative adjudication. Is that correct?
That is correct, Your Honor.
Okay. The Ombudsman approved the investigation report and created a new panel of investigators to conduct the preliminary investigation and the administrative adjudication, correct?
That is my understanding, Your Honor.
Now, the special panel of investigators filed the complaint, Annex D, to the petition of the Ombudsman with a new panel of investigators. The complaint expressly states that it covers the criminal and administrative aspects of the cases. Is that correct?
I think so, Your Honor.
Can you get the Annex D? And let's see. Can you read the first paragraph of the complaint of Annex D?
Okay. The first paragraph states, the special panel of investigators, Office of the Ombudsman, as nominal complainant, hereby files these criminal and administrative complaints against the following public and private respondents.
Okay, you can stop there. So the complaint covers both the criminal and administrative aspect of all these cases. Is that correct?
Yes, Your Honor.
And let us go to page 29 of the complaint. At the top of page 29, the top paragraph, it says there that the special panel of investigators they pray that the respondents be preventively suspended for 6 months without pay under Section 24. You see that?
Yes, Your Honor, if it's page 29.
Okay. So, and if you look at second to the last paragraph, on another count, for every count, they always recommend preventive suspension of all the respondents. So in this complaint, there are how many counts? I've lost count.
There are a lot, Your Honor.
But for every count, there is this recommendation by the special panel of investigators that the respondents be preventively suspended. Is that correct?
That is my understanding, Your Honor.
And so the prayer for preventive suspension applies to both the preliminary investigation and the administrative adjudication. That's the recommendation of the special panel of investigators,
This
correct?
is a single complaint, Your Honor.
Yes, it's a single complaint. Now, finding the preventive suspension in order, the new panel of investigators recommended to the Ombudsman the preventive suspension of respondents in both the preliminary investigation and administrative adjudication cases, correct?
Again, Your Honor, this is one complaint.
Yes. In short, the preventive suspension, according to the special panel of investigators, should apply to both the preliminary and administrative adjudication cases, correct? Is that correct?
Again, Your Honor, this is a single complaint.
Okay, single complaint. So the Ombudsman approved the preventive suspension of respondents, correct?
Yes, Your Honor.
Now, the reason for creating only one special panel of investigators to conduct both the preliminary investigation and the administrative adjudication is for reasons of economy and efficiency, correct?
Yes, Your Honor.
And that is allowed under the law, correct?
Yes, Your Honor.
But it does not prevent the Ombudsman from creating a separate panel for the preliminary investigation and a separate panel for the administrative adjudication, correct?
Correct, Your Honor.
And if the Ombudsman decides to create two separate panels, the panel for the preliminary investigation can recommend the suspension of the respondents in that preliminary investigation, and the panel for the administrative adjudication can also separately recommend the suspension, correct?
My understanding, Your Honor, is that it is with respect to the administrative complaint that the request for preventive suspension is generally asked.
But in a preliminary investigation, the Ombudsman has the power also to preventively suspend the respondent. That's the Naval versus COA case, correct?
I think, Your Honor, so long as the subject public official is within the administrative jurisdiction
correct.
of the
Well, we are
Office of the
assuming
Ombudsman.
that-
Yes.
That the Ombudsman has jurisdiction, and the question is, can she create a panel, separate panel to conduct the preliminary investigation, and can that panel recommend the suspension of the respondents, and can the Ombudsman approve it? Does she have the power? She has the power, correct?
Yes, Your Honor.
Okay. Now, what are the differences between a preliminary investigation and administrative adjudication with respect to the quantum of evidence? In preliminary investigation, what is required is probable cause, correct?
Yes, Your Honor.
In administrative adjudication, what is required is substantial evidence, correct?
Yes, Your Honor.
Okay. As to finality of decision, in preliminary investigation, if there is probable cause, the case goes to trial as there is no finding of guilt, correct?
Yes, Your Honor.
In administrative investigation, if the respondent is found guilty, the trial is over. And if respondent does not appeal, the decision becomes final and executory, correct?
Yes, Your Honor.
In appeal, in preliminary investigation, the respondent can appeal only to the Supreme Court in the petition for certiorari under Rule 65, Nava versus COA, correct?
Yes, Your Honor.
In administrative adjudication, the respondent can appeal to the Court of Appeals under Rule 43, not directly to the Supreme Court. That's Fabian versus Desierto, correct?
Yes, Your Honor.
As to penalty, in preliminary investigation, if the respondent is found guilty after trial, the penalty can be dismissal from service and imprisonment, correct?
Correct, Your Honor.
In administrative adjudication, the maximum penalty is dismissal from service as there can be no imprisonment, correct?
Correct, Your Honor.
So these are two different proceedings, the preliminary investigation and the administrative adjudication, correct?
Correct, Your Honor.
And the special panel of investigators conducted both preliminary investigation and administrative adjudication, correct?
Correct, Your
And
Honor.
the suspension order applied to both, correct?
I think so, Your Honor.
Yes. Now, what Respondent Mayor Binay appealed to the Court of Appeals is the suspension order in the administrative adjudication case, not the suspension order in the preliminary investigation case, correct?
It's a single joint order, Your Honor.
But under Fabian versus Desierto, the respondent cannot appeal to the Supreme Court, but only to the Court of Appeals and only in the administrative disciplinary case, correct?
Yes, Your Honor. But
So what was appealed by Mayor Binay to the Court of Appeals was the suspension order in the administrative investigation case, correct?
If I may just clarify, Your Honor, what was filed by private respondent was a petition for certiorari in the
Yes.
Court of Appeals. It was not an appeal.
And petition for certiorari under what rule?
I think, Your Honor, it's 65.
Not Rule 43?
Well, I suppose private respondent can confirm that later.
Okay. But under Fabian versus Desierto, what the respondent can do is to appeal to the Court of Appeals under Rule 43 on the order affecting the administrative disciplinary case. Whether it's a final order or a temporary or a provisional order, it has to go to the Court of Appeals under Fabian versus Desierto, correct?
Yes, Your Honor, decisions.
Okay. Now, there is also a suspension order here in the preliminary investigation case. That suspension order can only be appealed to the Court of Appeals via petition for certiorari under Rule 65, correct?
Your Honor, if I may confer with the Office of the Ombudsman, they are
Okay, you
more
can
familiar
confer.
with the bureaucratic processes.
Maybe we can call on the Ombudsman at this time. Justice,
Tanungin niya na lang.
bakit hindi ko tanong sa kanya? Kung anong...
Your Honor,
Would you like to
Yeah,
ask her
okay.
directly instead of asking at least 5 years to be passing on the answer? In which case, may we ask you to please share the podium with the Solicitor General? Be expeditious, so confirmation with your clients at this time is taking time.
Your Honor, the preventive suspension was issued only in the administrative cases, not in the criminal cases.
Okay, thank you, Ombudsman.
Okay, Ombudsman, thank you very much.
Okay.
Thank you, too.
Counsel? Okay, but in the preliminary investigation, the Ombudsman has a power also to suspend the respondents. Do you agree? That's the Nava versus COA.
again, Your Honor, if I may confer with,
Okay,
so
go
we can
ahead.
check their bureaucratic processes. Your Honor, not in the criminal aspect of the case.
No, no. Okay, the Ombudsman has just clarified that they issued a suspension order only with respect to the administrative case.
Yes, Your Honor.
But the Ombudsman has the power to suspend also the respondent in a preliminary investigation case, correct? Can you
Again, Your
consult
Honor,
client?
Can you ask your client that question?
the answer of my client is no.
Justice Ombudsman Morales, would you like to take a seat near the Solicitor General? So I see the answers being passed from ear to ear, at least 6 pairs. Justice Morales, please confirm with your client now.
Your Honor, the Office of the Ombudsman does not issue suspension orders in preliminary investigation cases. When probable cause is found, they file a case before the relevant court, and it is the relevant court that issues the preventive suspension order. It is the Sandigan Bayan.
Okay, have you come across Ombudsman versus Cordova? This is a decision of the Supreme Court penned by Justice Carpio-Morales.
If I may, no, Your Honor, not for this particular oral
Okay,
argument.
let me just read. After preliminary investigation, the OMB, Office of the Ombudsman, finding probable cause to hold respondent liable, which may warrant her dismissal from the service, issued order number 9 dated or issued order dated 9 November 12, issued order number 9 dated November 12, 27, placing respondent under preventive suspension without pay during the pendency of the administrative case, but not to exceed a total period of 6 months. So we have a precedent here where the Ombudsman can suspend the respondent in the preliminary investigation case, correct?
Your Honor, in the case that you mentioned, I think the phrase in the administrative aspect of the case was mentioned.
No, it says this is a preliminary investigation case because this went to the Sandigan. This is a preliminary investigation case. And the Supreme Court said, yes, she can be suspended.
Again, Your Honor,
Okay,
can we look at it for
Okay, look
purposes
at,
for memorandum?
Look at Section 63 of the Ombudsman's Act.
63.
Section...
Your Honor, it's only up until 42.
on the... I'm sorry, it's the... Section on the power to suspend.
That would be
24.
Section 24, Your Honor.
Okay. The Ombudsman can suspend any officer or employee under his authority pending an investigation. It does not say administrative or preliminary investigation. Any investigation. So what do you say? Can the Ombudsman suspend?
I can only attest, Your Honor, to the existing practice of the Office of the Ombudsman, and they have confirmed that they issue preventive suspension orders in cases that are docketed as CA or LA, meaning administrative cases.
Okay, but we have a case, Ombudsman versus Cordova. Okay, let's proceed. As of now, there is no appeal by the incumbent Mayor Binay Jr. from the preliminary investigation aspect of the case.
I am not aware of any appeal, Your Honor.
Because any appeal on the preliminary investigation aspect has to be brought before the Supreme Court on certiorari, correct?
Correct, Your Honor.
Not to the Court of Appeals, correct?
Correct, Your Honor.
So if the suspension order applied also to the preliminary investigation case, then the suspension order can be appealed only here to the Supreme Court, correct?
I suppose in theory, yes, Your Honor.
Okay. Let's go to the doctrine of condonation by re-election. The doctrine of condonation by re-election was introduced in 1959 in Pascual versus Provincial Board of Nueva Ecija. But it applies only to administrative cases, correct?
Yes, Your Honor.
It does not apply to criminal cases, correct?
Yes, Your Honor, that is aguinaldo.
So, what Respondent Binay Jr. is saying is the administrative aspect of this case has already been condoned by re-election. But even assuming that is correct, the criminal aspect of the case can never be condoned.
That is
correct?
true. That is true.
So, if there is a suspension order on the criminal aspect, that can never be condoned, correct?
Your Honor, it is simply that criminal cases have no bearing with the administrative liability of respondent. And therefore, the condonation policy cannot apply to the criminal aspect of the case.
So if the respondent is suspended preventively in a preliminary investigation, even if he was re-elected, he cannot invoke condonation by re-election, correct? Because
yes,
that's a
Your Honor.
criminal case.
Yes, Your Honor.
Okay, that's what I'm driving at. Now, under Section 27 of the Ombudsman's Act, it says all provisionary orders of the Office of the Ombudsman are immediately effective and executory. A preventive suspension order is a provisional order, correct?
Yes, Your Honor.
And it's immediately executory.
Yes, Your Honor.
Okay. So let me go to my last question, Counsel. on the power of judicial review. Now, what are the essential requirements before a court can exercise the power of judicial review under Angara versus Electoral Commission?
There must be a case or controversy. The proper parties must be there. It must be the lis mota. It must be the only way to resolve the case.
The constitutional issue must be raised at the first opportunity, and the constitutional issue must be the very lis mota of the case, correct?
Yes, yes, Your Honor.
Was this the case in the Court of Appeals? Was a constitutional issue raised by respondent Mayor Binay Jr.?
I do not think so, Your Honor.
Though there was no constitutional issue raised, so there was the Court of Appeals in resolving that case did not exercise the power of judicial review. It just exercised ordinary legislative power prescribed by Congress, correct?
Your Honor, if I may elaborate, in fact, that is the fundamental error of the respondent in this case. This case involves a pure application of statutory, Your Honor, of the statute, Section 14 of RA 6770. There is no constitutional question involved here, and therefore, all of the discussion of private respondent with respect to the expanded power of judicial review, with all due respect, has nothing to do with this case. This case involves judicial power of the Supreme Court under Article 8, Section 5, and judicial power as granted statutorily by Congress to the Court of Appeals.
Yes, because power of judicial review is the power of the court to determine the constitutionality of an act of the executive or the legislative or constitutional body. So you must raise a constitutional issue on an act or law, correct?
Yes, Your Honor.
And there is
again,
none here raised in the Court of Appeals.
none whatsoever, and none in this case, Your Honor.
Okay. Thank you, counsel. That's all.
Thank you, Mr. Justice Carpio.
Very interested in following up the issue of equal protection that was raised earlier by Justice Hardileza. Earlier, Justice Hardileza was careful to say implicitly that there must be symmetry in the process of appealing either preliminary orders, such as a suspension order by the Ombudsman, vis-a-vis equally coordinate bodies of equal rank, such as the Office of the President. So that we do not favor the Ombudsman by allowing direct access to the Supreme Court unless the Supreme Court, in a sense, consents to such direct access. So this symmetry is, he painted an argument that there must be symmetry that must be maintained is in the system of appeals and reviews. That is what I understood. From this, I want to go to a more substantive matter, because I think that this refers to the heart of the problem, and which is the concept of condonation. In the concept of condonation, it started in 1959. And have you had occasion to read the original decision in Pascual, Mr. Solicitor General?
Yes, Your Honor.
And did you have an occasion to analyze what the court was saying about whether there was sufficient case doctrine or standing for us to adopt the concept of condonation?
It is a policy adopted by the court, Your Honor, and just like any other judicial policy, there are usually competing views.
Okay. Let me read from the decision itself, no?
Yes, Your Honor.
In the absence of any precedent in this jurisdiction, we have resorted to American authorities. We found that cases on the matter are conflicting due to differences in statutes and constitutional provisions. Because here, they apparently were citing from state decisions, not a decision of the Federal Supreme Court, but state courts. You understood that to be?
Yes, Your Honor.
And was there effort taken on your part to find out what has happened to those cases and what was the context wherein those conflicting decisions were made?
In fact, Your Honor, we have pending petitions before this honorable court urging the court to revisit the condonation policy of the Honorable Court. And the studies are all there, Your Honor.
Let me just give you just a short rundown of the what happened to these cases, because I have
Okay, Your Honor.
gone through the original state cases and what has happened to that.
We would appreciate it, Your Honor.
Okay. The three cases cited in Pascual have been overturned by the legislature in their respective states. These are People ex rel, Bagshaw versus Thompson. That's a California appellate decision. That's State versus Blake, Oklahoma, and Board of Commissioners of Kingfisher County versus Shutter. For varying reasons. They basically said that the legislature has the duty to say that condonation of an offense committed by a subsequently elected person is not allowed to be brooked by public policy. And there is another U.S. case that was also discussed there, that condonation cannot apply to a continuing offense. In other words, where a crime or an administrative offense has started in a previous term and it succeeds and finds its way in a succeeding term, the condonation of a past act cannot work in order to lift the criminal and administrative liability for a subsequent act. Okay. Now, I was wondering whether, in the context of the fact that you have the 1973 Constitution, do you know if the 1935 Constitution has an equivalent provision with Article 2, Section 4 of the 1987 Constitution?
Section 2, Section... Article 2, Section 4, Your Honor, refers to the prime duty of the government to serve and protect the people. Are you referring to that particular provision?
Article 11, Section 1, rather.
Okay. Your Honor, I don't think there's any counterpart provision in the old Constitution.
The first time it found its way in was in the 1973 Constitution. That's why I find this interesting, this petition very interesting, because this is the first ombudsman, I think, no, unless I'm wrong, who has squarely raised the constitutionality of case law doctrine. Okay, the first time. Because if Pascual was never codified, and do I get it that we are a civil law country, Mr. Solicitor General Hilbay?
We are a mixed civil law and common law country.
With respect to the creation of obligations and liabilities arising from breach of obligations, does it not, is the symmetry doctrine not applicable to the fact that when a liability is created by law, such as the Administrative Code or the Revised Penal Code, the extinguishment of that liability must also be by law? Is that not symmetrical?
Well, I suppose, Your Honor.
Okay. In which case, if the foundation of the Pascual doctrine is because of case law that had been adopted, in fact, Pascual said that there are, of course, contrary distinctions, but they did not anymore explain in Pascual why, for that particular case, they were adopting the doctrine of condonation. Is it possible that, first, the Pascual case has weak legal foundations? Considering that you have the 1987 Constitution, which gives prime importance to accountability.
Yes. Your Honor, if I may restate the full breadth of our argument in this case. Our argument in this case is that the Court of Appeals has no jurisdiction whatsoever to issue an injunctive relief consistent with Section 14. Given that palpable lack of jurisdiction, the Court of Appeals did not even have the authority to consider condonation as a defense. Even on the assumption, Your Honor, that the Court of Appeals has jurisdiction over the issuance of a preliminary injunction or a TRO, The condonation doctrine does not apply because there were acts committed by private respondent that are standalone grounds for an administrative liability. Right. We also would like to argue, Your Honor, consistent with our pending petitions before the Honorable Court in another case, in fact, 2 cases, that it may be high time for the Honorable Court to consider the condonation policy, given that it is incompatible with the public accountability provisions of the Constitution.
Okay, I get it. The first count that I made of local government officials who are elected is that they run to about 43,000. No, there are 43,000 local government units as of now. Is that possible? Would there
I
be
can
anybody
confirm.
from the ILG here? Can you make sure that it somehow finds its way in the memorandum? How many LGUs are there?
Yes, Your Honor.
43,000. Now, I have no idea how many elective officials every LGU has. Would you have an idea?
No idea, Your Honor, but we will check and confirm for purposes of our memorandum.
Okay. Would 7, 9, or 10 be a conservative number?
No idea whatsoever, Your Honor.
Okay, let's peg it at 10. There can be a median, there may be 15, there may be 12, etc. You have the local government head, the vice head, and you have the council, correct?
Okay, yes, Your Honor.
If there are really 43,000 LGUs right now, you will have probably 430,000 elective officials. And it is important that this court deliver the correct message to 430,000 officials. Which brings me to the equal protection issue here. You are basically saying that these 430,000 officials can commit administrative offenses ranging from simple misconduct all the way to serious misconduct, gross violations, dishonesty. I'm not an expert in the range of administrative offenses. They just must ensure that they get reelected, and any preventive suspension or any investigation or any administrative finding by the Ombudsman will have to stop. Is that the message that is going to be delivered if we continue with the condonation doctrine?
No, Your Honor, that is why, given that reality, it might be high time for the Honorable Court to reconsider that doctrine in the first place.
In fact, if you look at the way that the court was deciding the condonation doctrine, in most cases, you can say that the recitation of the phrase in Pascual was simply obiter. So can you make a distinction between pronouncements then that were doctrinal and were based on facts and law, and pronouncements that were just obiter, lifting the language of Pascual?
We'll do that in our memorandum, Your Honor.
The other point that I wish to find out is the concept of a continuing offense. If there is still room for us to validate or to affirm the continued existence of the doctrine of condonation, if ever, should it, as long the defense that I read in the respondent's position paper, is that as long as the incipients of the act that has been complained of as illegal happened in a previous term, his acts that is just a continuation, i.e. payments made in an incumbent term, are also wiped out by the doctrine of condonation.
That is their position, Your Honor.
So do you think that there is also time for us to review that matter?
Yes, of course, Your Honor.
Okay. Now, can you also try to enlighten us about the doctrine of constructive knowledge that the court had laid out in talking about Pascual et al., Pascual and subsequent cases? And the court was saying it must have electorate is charged with the knowledge of the wrongdoing of the one whom they elected in a previous term, such that the electorate is deemed to have forgiven him or her of such offenses.
That is true, Your Honor.
Okay, what is the legal basis for this constructive knowledge? Because I don't see it in the rules on judicial notice. I don't see it in statute. In fact, in the cases that were cited in Pascual, and if you shepherdize that, you will find out that there are contrary decisions that say it is impossible for an electorate to be conducted, to be charged with knowledge of past wrongdoing.
Yes. Well, I suppose, Your Honor, that the idea of constructive knowledge is an accessory to the doctrine of condonation.
It is an accessory, but what is the foundation of that constructive knowledge? Because I cannot see any parallel there where, for example, an act that had been hidden and that had not been publicized. In fact, there is a statement here that an act that had been hidden and not been publicized cannot serve as the basis of the application of the doctrine of condonation.
Yes, sir. The basis, Your Honor, is pure judicial policy, which we said, Your Honor, that the court can reconsider.
When there is a judicial policy and it seems to be founded on an infirm foundation, especially considering the language, the very clear language of the 1987 Constitution, and you juxtapose it with the fact that we have a mandate to pursue relentlessly graft and corrupt practices by creating a special office, do you think that it is no longer appropriate to maintain that condonation policy?
Yes, Your Honor. In fact, it is within the full discretion of the court to reconsider its existing judicial policy in relation to condonation, such that that policy may be updated with respect to the norms that are in the 1987 Constitution.
In cases 1959, before the 1987 Constitution, the power to suspend then, the power that was being reviewed, was the power that was being exercised by the President through the Secretary of Interior and Local Government. So you had a politician, the President, through his Secretary of Interior and Local Government, another politician, his alter ego, imposing the power of preventive suspension as an adjunct of an administrative finding. Is that correct?
Yes, Your Honor.
But the situation has changed dramatically. With the 1987 Constitution and the creation of the Office of the Ombudsman, the ability of the political offices to create a scenario wherein for vendetta, and that was what the implicit fear of the court was, to punish a political opponent, has already changed with an organization that is supposed to conduct full-time investigations of wrongdoing.
Yes, Your Honor.
Does this therefore change the landscape?
Yes, of course, Your Honor. The Ombudsman is not a politician. She is independent. Her office is meant constitutionally and structurally to be independent, and therefore the idea that the power to suspend may be used for purposes of vendetta does not apply to the office of the Ombudsman.
Now, I'm going to ask you if you are able to have account of the elective officials right now, whether it is at the local government level, the national level, even all the way to the impeachable officers. If you can give us account of how many elective officials there are who will benefit from the continuation of the doctrine of condonation, can you contrast this with the number of appointive government employees who will never be benefited by the doctrine of condonation?
Your Honor, we will do that in our memorandum.
Okay, that's for now. Justice Bernabe.
Good afternoon.
Good afternoon, Justice Bernabe.
Yeah. Is the Ombudsman a quasi-judicial agency?
Yes, Your Honor. It performs quasi-judicial functions.
And it was classified as such also in Fabian versus Diciendo.
Yes, Your Honor, that is correct.
No, and therefore its decision in administrative cases is appealable before the Court of Appeals under Rule 43.
That is true, Your Honor.
Subject, of course, to certain exceptions where the penalty involved is just a fine, in which
Yes.
case the decision is final and executory, and the remedy is certiorari
Certiorari.
under Rule 65.
That is true, Your Honor.
No, but in this case, there is yet no decision in the administrative investigation,
None, Your Honor.
and therefore, appeal is still premature.
Yes, of course, Your Honor. What we have is an interlocutory order issued by the Office of the Ombudsman preventively suspending respondent.
Okay, so this is an interlocutory order of
Yes.
preventive suspension.
Yes,
And
Your Honor.
therefore, the allegation is that the Ombudsman committed grave abuse of discretion.
Yes,
Is
Your
that
Honor.
it? And therefore, the certiorari petition should have been filed before the Court of Appeals, as it was filed.
Either in the Court of Appeals or in the Supreme Court, Your Honor.
But of course, in observance of the hierarchy of courts, it should be the Court of Appeals.
That seems to be the case, Your Honor.
Okay, and in fact, you have recognized the CA's certiorari jurisdiction since you only prayed that the TRO be nullified.
That is the only question in the Court of Appeals, Your Honor.
Okay. Now, by recognizing the certiorari jurisdiction of the Court of Appeals, do you equally recognize that the Court of Appeals is a body higher in rank than the Ombudsman
No, Your Honor.
because it is an independent
That
constitutional
is true, Your Honor.
body? Now, when courts take cognizance of a certiorari petition, normally their exercise of jurisdiction carries the power to issue ancillary reliefs like TROs and injunction. Is that correct?
It depends, Your Honor, if it is given by the Congress.
Okay, and in this case, you claim that under Section 14, courts, except of course the Supreme Court, could not issue writs of injunction that would delay the Ombudsman's investigation, except of course when there's a prima facie finding of lack of jurisdiction on the part of the Ombudsman. Is that correct?
Your Honor, that is clearly expressed in the statute.
And of course, under the broad term courts, the Supreme Court is not included.
Of course, Your Honor, Section 14 does not implicate the powers of the Supreme Court.
Now, can Congress take away the Court of Appeals' power to issue an injunction in the exercise of its certiorari jurisdiction when the Court of Appeals is authorized to resolve the main petition on its merits?
Yes, Your Honor. It is not entirely strange or unconstitutional or even inconsistent on the part of the Congress to provide original jurisdiction for certiorari, but withhold the power to issue injunctive relief.
Even if it would not be able to fully exercise its judicial power absent the authority to issue ancillary reliefs.
Even if that is the case, Your Honor, there can be no question that can be done, given that the Court of Appeals is a statutory court. Given that Congress can remove all powers from the Court of Appeals, that means that Congress can also define in particular those powers.
Okay, when you speak of certiorari, you either refer to grave abuse of discretion or lack of subject matter jurisdiction.
Yes, Your Honor.
Okay, where do you anchor your petition? Is it on grave abuse of discretion or on lack of subject matter jurisdiction?
Lack of jurisdiction on the part of the Court of Appeals to issue an injunctive writ on the part against the Office of the Ombudsman, given Section 14 of 6770.
Okay, now if the court rules the CA had no authority to issue the subject TRO,
Yes, Your Honor.
can the Supreme Court issue a TRO against the preventive suspension since Section 14 does not cover the Supreme Court?
It is within the discretion of the Honorable Court, but allow me to just emphasize, Your Honor, that in cases that have been decided by this Honorable Court, the policy is one of deference to the judgment of the Honorable Ombudsman. And so even if there is that authority on the part of the Supreme Court to issue injunctive writs against the Honorable Ombudsman, that remains to be an exception rather than the rule.
But considering the jurisdiction of the CA over the main case, the certiorari petition, then the CA has authority to resolve the case on its merits because it's only the TRO that you are questioning.
The same analogy, Your Honor, applies with respect to government infrastructure projects. As we have mentioned, under 8975, RTCs can hear petitions questioning contracts involving national government infrastructure projects. But given the specific policy in RA 8975 prohibiting them from issuing injunctive writs, they have no authority to do that. In fact, Your Honor, we have stated in our short paper that lower court judges have been suspended and fined for issuing injunctive writs in violation of that clear statutory policy.
Okay, so the resolution of the merits of the case, in this case, is vested with the Court of Appeals, and it's only the TRO that you are assailing. And that is the only thing that the Supreme Court shall resolve.
The clear policy, Your Honor, embodied in Section 14 is a policy against injunctions. That much is very clear, Your Honor. Whether or not the Court of Appeals has the power, the original jurisdiction, the authority to hear the certiorari petition, or only the Supreme Court, is dependent on the policy of the Supreme Court, given its power to determine processes.
All right, thank you very much.
Thank you, Your Honor.
Justice Perez.
Good afternoon, Mr. Justice Perez.
Good afternoon, Mr. Acting Solicitor General. I was just bothered by your statement a while ago in relation to the questioning of Justice Hardelesa that injunction itself is the delay. Does that mean that there is no allowable injunction under Section 14? Because injunction itself, you said, is the delay. And it is the delay which is prohibited by Section 14 such that all injunctions are disallowed.
With respect to the particular facts of this case, Your Honor, the injunction is the delay because under Section 21 of the Ombudsman Act, there is no question whatsoever that the private respondent is within the administrative jurisdiction of the Office of the Ombudsman. As we have said, Your Honor, the example of an instance where there is a prima facie investigation that is outside of the jurisdiction of the Ombudsman is when she investigates and preventively suspends an impeachable public officer, a member of Congress, or a member of the judiciary. That is as clear as it can get, Your Honor.
And then what is the relevance then of Section 24 of the law itself on preventive suspension, which was mentioned by the Ombudsman in her preventive suspension order? I am particularly referring to the statements which says that the requisites are when the evidence of guilt is strong, charge against such officer or employee involves dishonesty, charge would warrant removal, respondents continue to stay in office by prejudice. In other words, these are the guidelines for the issuance of the preventive suspension order, and this is determined by his judgment. Cannot the judgment of the Ombudsman be gravely abused?
That is a possibility, Your Honor, for looking at the full spectrum of possibilities. But the general rule, Your Honor, is that the phrase in his judgment is a textual commitment to the Office of the Ombudsman of that discretion. And while it may be possible for her to commit grave abuse of discretion, right, correctable by a writ of certiorari, right, only the Supreme Court can issue a temporary restraining order, right, in 65 petitions, given that Congress has clearly withdrawn from the Court of Appeals the power to issue any injunctive writs to delay that investigation.
That statement, what is the relevance of the, what you mentioned a while ago, the expanded jurisdiction? Note, it is not just the expanded jurisdiction of the Supreme Court, but of any court of justice. And that includes the Court of Appeals.
Thank you, Your Honor. That is, in fact, the main point that I stressed earlier about the fundamental error of understanding in the short paper of the private respondents, with all due respect. Judicial review, Your Honor, involves the power to nullify an act of Congress or an act of any government agency. There are no constitutional questions here. We are not dealing here with the expanded judicial review power of the Supreme Court or any other court. We are dealing here with judicial power The judicial power of the Philippine Supreme Court is derived from Article 8, Section 5(1) of the Constitution with respect to its original jurisdiction. The judicial power of the Court of Appeals is entirely dependent on the Congress itself.
The judicial power of any court of justice is defined by the second paragraph of Section 1. And it includes the expanded jurisdiction.
Again, Your Honor, let me give you an example. Can the Congress remove the regional trial court? Can Congress pass a law removing or abolishing the regional trial court? Well, of course, because the regional trial court is a statutory court. Can the Congress define
Yes.
the jurisdiction of the RTC and the
Yes.
CA, giving it only certiorari but no prohibition, mandamus but no habeas corpus jurisdiction? Absolutely, Your Honor. And so what we're saying is that
will you stand by that statement? Are you saying that the Congress can defy the provision of the Constitution itself?
again, Your Honor, let me restate. Under Article 8, Section 2, the Congress has constitutional authority to define, apportion,
Subject to the provisions of the basic provision defining what judicial power is.
it is Congress, Your Honor, that defines the extent of the judicial
And
power
it's the
of,
Constitution which limits the power of Congress.
with respect to the original jurisdiction of the Supreme Court in Article 8, Section 5.
No, it doesn't mention the Supreme Court alone. It mentions courts of justice, and that includes, I repeat, the Court of Appeals.
Again, Your Honor, let me go back to my example. If the Congress can abolish the MTC, then no MTC can exercise any judicial power. It is as clear as that, Your Honor. At least that is how we submit it. Thank you, Mr. Justice Perez.
Justice Del Castillo, then Justice Leonen.
Good afternoon, Mr. Justice Del Castillo.
Mr. Solicitor General, we've discussed condonation by re-election. And you mentioned earlier that it has already been brought out here that this concept has been brought about by case law. So there is really no law that supports this doctrine.
It's pure jurisprudential policy, Your Honor.
You're not obviously in favor of this.
No, Your Honor.
And from what you've said so far, it seems that you want this doctrine abandoned.
In fact, Your Honor, there are two pending cases before this honorable court where the Ombudsman and the Solicitor General has requested just that.
And you're saying that it is this, the court, the Supreme Court, that can do this.
In the same manner, Your Honor, that condonation is a Supreme Court created policy, it can do away with the same policy.
But you cannot expect that of the Court of Appeals.
Your Honor, it is only the honorable court that can create judicial policy.
So you cannot say therefore that the Court of Appeals committed grave abuse of discretion in coming out with those three resolutions because they were just following case law.
Your Honor, our argument in this case is that the Court of Appeals was precluded, is still precluded from considering the condonation doctrine given that it did not have jurisdiction in the first place to issue a TRO on the basis of the fact that the administrative liability may have already been condoned. We don't reach, Your Honor, the question of condonation. Only a court with jurisdiction can consider defenses, and a court without jurisdiction has no authority to consider a particular defense.
Well, the opposing party, of course, maintains the opposite view.
That is understandable, Your Honor.
Thank you, Chief.
Thank you, Mr. Justice Del Castillo.
Justice Leonen.
Chief, I yield to Justice Reyes first.
Justice Reyes.
Good afternoon, Mr. Justice
Mr. Counsel.
Reyes.
Actually, these are not interpellatory questions, but only affirmatory or clarificatory questions in order to guide me in the disposition of, in my position regarding the disposition of this case.
Yes, Your Honor.
I just want to know firmly the case for the petitioners. Is it your position that the Ombudsman's independence was gravely undermined by the Court of Appeals when it issued the TRO?
Yes, Your Honor.
Then, is the TRO, is it also your position that the TRO was issued with grave abuse of discretion since Mayor Binay has no claim or right in esse to his position as mayor? And B, the preventive suspension was a lawful exercise of discretion of the Ombudsman?
Your Honor, the grave abuse of discretion arises from the lack of statutory authority of the Court of Appeals to issue an injunctive relief in the first place. No one questions, Your Honor, the right of private respondent to hold office as mayor. But that is not what is in question here. What is in question here is, given the right of the Honorable Mayor to stay in office, are there higher principles of constitutional and statutory law that allow the Office of the Ombudsman to remove him temporarily so that it can perform its constitutional and statutory functions? The answer is yes.
Now, Mr. Counsel, is it your position that the contempt proceeding is illegal and improper for having been issued against an impeachable officer?
Yes, Your Honor, in particular given the facts of this case.
And lastly, is it your position that the assailed resolution will create a dangerous precedent for public officials and employees to thwart or delay the investigations or prosecutions?
Absolutely, Your Honor. We consider this case as an opportunity for the Honorable Court to protect a core function of the Office of the Ombudsman. When the Office of the Ombudsman issues a preventive suspension order that is an exercise of discretion on her part, that the best way to proceed with an investigation is by issuing an interlocutory order called a suspension order. The danger that courts may interfere with that power is grave and palpable, and therefore correctable by certiorari from this honorable court.
Thank you, Mr. Counsel.
Thank you, Mr. Justice Reyes.
Justice Leonen.
Good afternoon, Counsel.
Good afternoon, Mr. Justice Leonen.
Let me just clarify the facts as your client sees it in the meantime. What triggered the creation of the Special Investigation Committee that gave that report now in Annex D of your petition?
My understanding, Your Honor, is that there was a complaint that was filed.
When was the complaint filed? In your pleading, it is June 2014. Would you confirm that? In your petition?
Yes, Your Honor.
Okay. Of course, perhaps in your memoranda, we would want to know the exact date of the complaint as well as a copy of the complaint itself. Now, this was filed by Attorney Bondal and among others. Is this not correct?
Correct, Your Honor.
And this is in relation to what, Counsel?
The Makati parking building, Your
Okay.
Honor.
And Annex D was the product of that Special Investigation Committee. Am I not correct?
Yes, correct, Your Honor.
And from June 2014 to March 2015, we can assume that the Special Investigating Committee perused through the records as well as the witnesses that were presented by the complainant in this case. Is that not correct?
That is a reasonable assumption, Your Honor.
And we can say that that was an act of the Office of the Ombudsman perusing through the evidence, as well as, of course, the current incumbent, Justice Carpio-Morales, would have read the entire report as well as the annexes before she ordered the issuance of the preventive suspension.
That is a reasonable assumption, Your Honor.
Would you know the extent of the documentary evidence that was presented? In other words, would you know the last marking of the documentary evidence?
No, Your Honor.
It is per my perusal of the documents that you have submitted before this court, It is letter Y, submarking 12. And just for information, that would have meant 26 times 2 minus 1 documents. Is that not correct?
I suppose, Your Honor, that's...
Which is equivalent to how much?
We can put that in our memorandum, Your Honor.
In any case, counsel, then I notice in your position paper an allegation which is similar to that in your petition. I refer to page 17, and it is about a payment of 449,058 pesos and 75 centavos to Hillmark. This is on page 17 of your position paper. May I know why this fact was singled out among all the facts that are contained in Annex D?
This fact was singled out precisely because of the problem with respect to the condonation doctrine. The basic argument of the Office of the Ombudsman is that even if the condonation doctrine were to apply in this case for purposes of allowing the Court of Appeals to issue a TRO, right, the Ombudsman would still have administrative jurisdiction over the private respondent, given that there are current payments which are in violation of COA circulars, and that therefore these are standalone violations that subject private respondent within the jurisdiction of the Office of the Ombudsman.
In other words, you are saying that this particular act of payment to Hillmark happened during the current term of the current mayor of Makati.
Yes, Your Honor.
Now, this payment was done in relation to a contract which was questioned precisely by the Special Investigating Committee as a result of the complaint of Mr. or Attorney Bondal. Is this not correct?
Yes, Your Honor.
And the allegation is, to a certain extent, that the contract was illegal because of certain violations of law. Is this not correct?
Yes, Your Honor.
Now, Counsel, Mr. Solicitor General, is a contract that is illegal validated by subsequent elections?
No, Your Honor.
So the illegal contract subsists, notwithstanding the fact that the incumbent that participated in the contract was elected even by a landslide.
Yes, Your Honor.
Are you saying that Vox Populi cannot change law in this jurisdiction? Vox Populi in general, simply by election, that we can change the law?
Okay.
Or do we need representatives elected to present a bill, go through 3 readings, go through the proper procedure in the local government code or perhaps in the Congress before a law is changed? Is that not correct?
Correct, Your Honor.
Yes. So even if we assume for the sake of argument that there is such a thing as administrative condonation for the administrative liability, that contract was never validated according to your the findings of your client. Is that not correct? By election?
Correct, Your Honor.
Yes. So I just wanted to clarify that particular fact. Now, can I borrow your slide relating to Section 14 of the Ombudsman's law? There are 2 paragraphs in this provision. Am I not correct, Counsel?
Correct, Mr. Justice.
Now, the first paragraph refers to not a TRO, it refers to no writ of injunction. Is that not correct?
Correct, Your Honor.
The second paragraph refers to 2 different other remedies, as differentiated from the first paragraph. The second paragraph says, no court shall hear any appeal. That's another remedy. Is that not correct?
Correct, Your Honor.
And there is an or, which is a conjunctive, which means that it is different from the noun that it is supposed to have followed. So therefore, application for remedy against, so that's a different a set of remedies from an appeal. Is that not correct?
Correct, Your Honor.
And the application for remedy refers to application for remedy against the decision, which means perhaps a final act, or findings of the Ombudsman. Is that not correct?
Correct, Your Honor.
So we have 3 things here. One is a writ of injunction. As the second is an appeal. The third is this thing about application for remedy against the decision or findings of the Ombudsman. Now, of course, you may tackle this more in your memoranda, but the nature of a preventive suspension under Section 24 prior to the filing of an administrative case, actually, for liability or preliminary investigation. Just say preventive suspension because the Ombudsman is investigating. Where would you put that? Is it a findings of the Ombudsman, a decision of the Ombudsman, or is it subject to appeal?
Your Honor, our position is that it is an interlocutory order.
Interlocutory order, so let us remove no court shall hear any appeal, which was the subject, of course, of several cases already mentioned. Fabian in the case of administrative liability, and Nava in the case of criminal liability. Is that not correct?
Correct, Your Honor.
Okay, now, would you know what rule covers injunction in the rules of court?
Rule 58,
58.
Your Honor.
That is under the general rubric, if Justice Bersamin will correct me if I will be mistaken, under the rubric of what is called provisional remedies. Our resident expert, because Justice Peralta is not here, so Justice Bersamin for a while. So provisional remedy, injunction. 57, on the other hand, refers to what provisional remedy, counsel? Rule 57 refers to?
Preliminary attachment.
And then 59 refers to receivership, and 60 refers to support pendiente lite, etc. Now, provisional remedies have a particular nature. They are supportive of a remedy. Is that not correct?
Yes, Your Honor.
Okay. Now, we go to the Constitution. Section 5, subparagraph 5 of Article 8 of the Constitution. If you have a copy of the Constitution, can you please read that provision? Section 5, Article 8, the judiciary, subparagraph 5. Would you kindly read that provision?
Promulgate rules concerning the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts.
We can stop with that. Promulgate rules concerning pleading, practice, and procedure in all courts. This is the power, the competence, the jurisdiction of what constitutional organ?
The Supreme Court, Your Honor.
The Supreme Court. This is different from Article 8, Sections 1 and 2, which have already been discussed with you by my other colleagues. Is that not correct?
Correct, Your Honor.
Okay, so in Section 2, apportion jurisdiction, that is the power of Congress. Is that not correct?
Correct, Your Honor.
On the other hand, the power to promulgate rules is with the court. Is that not correct?
Correct, Your Honor.
A TRO and a writ of preliminary injunction, would it be a separate case, or is it part of litigation in an ordinary case?
It is ancillary remedy, Your Honor.
In fact, it originated as an equitable remedy. Is that not correct?
Correct, Your Honor.
In order to preserve the power of a court so that at the end of litigation, it will not be rendered moot and academic. Is that not correct?
Correct, Your Honor.
In that view, isn't Section 14, first paragraph, unconstitutional?
No, Your Honor.
Why?
Because the Congress has a full constitutional authority.
Can Congress say that a court cannot prescribe motions to dismiss under Rule 16?
Your Honor, Congress cannot impair the power of the court to create remedies.
What
But
about Bill of
Congress-
Particulars? Can Congress say no court shall have the power to issue the supplemental pleading called Bill of Particulars? Cannot, because that's part of procedure.
That is true.
Or for that matter, no court shall act on a motion to quash. Is that not correct?
Correct, Your Honor.
So what's different with the writ of injunction?
A writ of injunction, Your Honor, requires the existence of jurisdiction on the part of a court that was created by Congress. In the absence of a jurisdiction,
No,
right,
writ of injunction does not attach to a court. In other words, when they create a special agrarian court, it has all the procedures with it, but it does not attach particularly to that particular court. Is that not correct?
when Congress, Your Honor, creates a special court,
Again, counsel, what statute provides for a TRO? Created the concept of a TRO. It was a rule of procedure,
Yes.
and the rules of court. Is that not correct?
yes, Your Honor.
And a TRO and a writ of preliminary injunction does not exist unless it is ancillary to a particular action in a court. Is that not correct?
Correct, Your Honor.
And perhaps you can cover this more particularly in your memoranda. I think this was also being referred to by Justice Ardelesa a while ago.
Yes, Your Honor.
But on the other hand, we are not only concerned with that constitutional issue. We are also concerned with the constitutional issue regarding the power of a new entity created under the 1987 Constitution, a constitutional organ which the constitutional commissioners thought should be very powerful. And this is called the Ombudsman. Is that not correct?
Correct, Your Honor.
Which meant, therefore, that we are now being asked to see or demarcate the boundaries between the power of this court and, of course, looking at the discretions of the Ombudsman relating to preventive suspension. Is that not correct?
Your Honor, our case here is rather simple. The Court of Appeals issued a TRO in the absence of an authority, in fact, in the face of an express prohibition by the Congress itself.
We, of course, appreciate that you see it as a simple case,
Yes,
but we would not have called for oral arguments in Baguio City had it not been a difficult case and a complex one at that. Of course, you would agree with me that this is a difficult case not only because it is complex, but it is also a difficult case because it is political. And therefore, we have to be careful in terms of laying down our legal premises so as not to be misinterpreted by the public at large. But in any case, the point here is that the issue here is relating to the power of preventive suspension of the Ombudsman. Now, is the power of preventive suspension of the Ombudsman statutory, or is it inherent in a constitutional power that of the Ombudsman?
It is statutory, Your Honor.
Really? Article 11, Section 13, subparagraph 1, the Ombudsman has the power to investigate. Is that not correct?
Correct, Your Honor.
Yes. And the power to investigate, of course, includes all the necessary powers that are included in it. Angara versus Electoral Commission. In drawing out the boundaries of constitutional departments, it is not only what is clearly stated, but everything that is related to it. Is that not correct?
I would have to disagree, Your Honor. While
In
the
Bobensiong versus Ombudsman, decided by this court under the ponensya of Justice Puno, he explained, or the court explained, through Chief Justice Puno, the nature of preventive suspension. Why is there such a power, Counsel?
Because Congress gave that authority that power.
No, why is there the right to preventive suspension? Why is there that power? What is the reason for granting the Ombudsman the power of preventive suspension?
To aid it in its investigatory
To aid in its
functions.
investigation, because there is a possibility that without preventive suspension, a powerful official that has won an election would be able to hide the records, talk to the witnesses, use its power. And I think that those that drafted the Constitution, which is all of us, not simply the constitutional commissioners, envision the reality that in our country, those in political power have power vis-a-vis these kinds of investigation. Would you agree with me, Counsel, that it is very difficult to root out corruption in this country?
Oh, it's a given, Your Honor, I agree.
It's a given. And it's very difficult to root out corruption because it is easy to allege, such as 50 million pesos paid to a Court of Appeals justice, but very difficult to prove unless there is somebody that really comes forward to actually prove it. Is that not correct?
Correct, Your Honor.
In fact, the Ombudsman was given an extraordinary power that in spite of hearsay, in spite of anonymous complaints, the Constitution says that she may proceed to look for the evidence proactively and not passively like a prosecutor. Is that not correct?
Correct, Your Honor.
Yes, and the power to preventively suspend an official, therefore, is intricately woven into the power of the Ombudsman to investigate. Is that not correct?
I would have to disagree, Your Honor.
Perhaps just cover that in your
Yes, Your Honor.
memoranda, which means, therefore, that if that were the case, if the assumption that I am saying is correct, not that I'm saying that that would be my position, but if that would be correct, then the power of judicial review would be something that is constitutional, and therefore it should be deferential. Of course, you have cases to this effect, like Ombudsman versus Evangelista, also written by Chief Justice Puno in the past. Is that not correct? that this court has followed an entrenched and long-standing policy to render deference to the power of the Ombudsman to preventively suspend. Is that not correct?
Correct, Your Honor.
Yes. By the way, what is the irreparable injury if a public official, an elected mayor, is suspended for 6 months?
None, Your Honor.
What is the irreparable injury to the public office, if any?
A distraction in the performance of certain public functions.
You say none. Is it because there is always succession in terms of the public office?
There is succession, Your Honor.
So we are talking here of irreparable injury of the incumbent? Is that what we are saying?
With respect to this case, Your Honor, we were talking about, with respect to this particular petition, we're talking about the irreparable injury to the core functions of the office of the Ombudsman.
No, I'm just asking about the irreparable injury that would happen if a preventive suspension is issued against a public official.
None, Your Honor.
What about to the electorate that voted that person into power?
The right of an elected public official to perform his or her functions will have to be balanced with the power of the Ombudsman to conduct an investigation.
Are you saying that that a public office is not simply something that operates in a vacuum? A public office has certain powers, privileges, and disqualifications attached to it as a result of the Constitution and law.
Yes, Your Honor.
And by the Constitution, any public office is subject to this principle. Public office is a public trust. Is that not correct?
Correct, Your Honor.
Because it's in the Constitution, it is not created by the number of people that vote for that person. Is that not correct?
Correct, Your Honor.
And therefore, it is always vested in that public office. Is that not correct?
Correct, Your Honor.
So even if that person has been elected by 110% of the registered voters, of course, that is impossible.
I agree, Your Honor.
The system in the Constitution is that there is a procedure, and this is by the Ombudsman, to actually give life to that particular principle. Is that not correct?
Correct, Your Honor.
So, and of course, the incumbent cannot say that his due process rights have been violated, or could he?
No, Your Honor.
Because in due process, there are three things: life, liberty, or property. Is that not correct?
Correct, Your Honor.
And a person's security of tenure is not a right to life. Is that not correct?
Correct, Your
It's a
Honor.
privilege. It is not a liberty because it is subsumed under so many regulations, from civil service to audits. And finally, we look at the concept of property. Is that not correct? In other words, is public office property for the incumbent protected by the due process clause?
To some extent, yes, Your Honor.
Only to the extent that he is guaranteed security of tenure, but not to the extent that he is entitled to it like a king or a queen or a prince or a princess. Is that not correct?
Correct, Your Honor.
Carpio versus Civil Service Commission, correct? And I
Correct.
saw this cited, I think, if I'm not mistaken, in both position papers, that that is not a property right, not subject to due process. Now, assuming for the sake of argument that Section 14 is not unconstitutional, meaning to say that there is nothing wrong with it.
There's
What
none,
is
Your Honor. There's none.
the power of the other courts to issue a writ of injunction is subject to prima facie evidence that the subject matter of the investigation is outside the jurisdiction of the Office of the Ombudsman.
Yes.
So there has to be prima facie evidence. Now, in your view, what was the prima facie evidence that the Ombudsman did not have jurisdiction in this case?
None, Your Honor.
And if
because-
there is none, and a court issues a writ of injunction, assuming this to be valid, did that court breach its jurisdiction, gravely abuse its jurisdiction, or issued that order without jurisdiction?
Without jurisdiction.
Without jurisdiction. Next, I just want to clarify. What is the effect of American cases in our jurisdiction?
None, Your Honor.
And if a doctrine was based upon an American case, not a statute, not a provision in the Constitution, what is the standing of that doctrine?
Well, it's good doctrine, Your Honor, insofar as the members of the Honorable Court itself have decided to adopt
If it
a
is good
particular
doctrine, therefore, good doctrine until a court reverses it, then therefore should the public be entitled to rely on that particular doctrine.
Correct, Your Honor.
Isn't a bad precedent always a bad precedent?
I suppose, Your Honor.
Yes. In any case, can the Court of Appeals determine its own jurisdiction?
No, Your Honor, the Court of Appeals is a statutory court. Only
Wait.
Congress can create
In
jurisdiction.
other words, if there is a motion to dismiss filed with the regional trial court on the ground that the court does not have jurisdiction, if the Court of Appeals, there is a motion or there is a comment that is filed stating that the Court of Appeals does not have jurisdiction, you mean to say that those courts cannot determine its own competence?
A court that is without jurisdiction has jurisdiction to determine itself that it has no jurisdiction.
Yes, competence, correct? Like in arbitration. But therefore, a court has jurisdiction to determine its own competence. Now, in relation to the petition for contempt, and this was asked a while ago, has there been a chance for the Court of Appeals to render a ruling as to whether or not it has jurisdiction to issue a citation for contempt against an unimpeachable officer?
None yet, Your Honor, so far as I know.
And therefore, is there a plain, speedy, adequate remedy in that court first? You see, there is wisdom in those kinds of rules, that the Supreme Court will have the second say, because the more minds are put into a particular question, the better it is for us to take a look at it. This is the second part of your petition. Is this not correct?
Correct, Your Honor.
Yes. Is there a difference between nullifying an act of the Ombudsman and citing the Ombudsman in contempt?
Yes, of course, Your Honor.
Definitely, an act of the Ombudsman nullified by any court. Is that not correct?
Yes, Your Honor.
Judicial review subject to the conditions stated by Justice Carpio a while ago. But in terms of contempt, would you say that with respect to the Ombudsman, this is a very novel issue?
Yes, Your Honor.
Yes. And the Ombudsman is not like the COMELEC, in the sense that there are similarities, of course. Both are constitutional organs, constitutional institutions. But with respect to the Ombudsman, there is something more fundamental, because to ensure that public office is a public trust pervades everybody, from COMELEC to COA to this court. Is that not correct?
Correct, Your Honor.
And therefore, some of the precedents like Philippine Guardians and information technology can refer to the COMELEC, and perhaps is good law with respect to the COMELEC. But this is the first time that this court is confronted with this question as to whether courts of law can issue contempt against the Ombudsman that has certain functions under the Constitution. Is this not correct?
Correct, Your Honor.
Yes. I have no further questions at this time.
Madam Chief Justice.
Justice Velasco, first Justice Ardaleza, then Justice Bersamin. Okay, Justice Velasco, then.
Good afternoon, Mr. Solicitor General.
Good afternoon, Mr. Justice Velasco.
I would just like to take off from the previous questioning of Justice Lonen regarding the facts pertaining to the filing of the complaint. When was the special panel of investigators created? Would you know the date of the creation of the panel? The organization of the panel?
Do you have the date?
Ayun na ba?
I am told, Your Honor, that it is sometime in September 2014.
2014. And I suppose there was an order issued regarding the creation of such special panel. It was contained in an order, either coming from, I guess, the Office of the Deputy Ombudsman or the Office of the Ombudsman itself, right?
Yes, Your Honor.
Okay. And in that order, do you have a copy of that order creating the special panel?
I currently don't have a copy, Your Honor. I can provide the court in our memorandum.
What directive is contained in the order creating the special panel regarding the subject matter of the investigation to be conducted by the special panel? Would you know?
If I may get the
Yes,
documents
please.
from my client. It's a general order, Your Honor, to investigate alleged irregularities with respect to the Makati building parking.
So it's just a directive, which is couched in general terms, to investigate alleged irregularities pertaining
Your
to
Honor, the Ombudsman is here. She has personal knowledge of the
Okay.
facts.
Yes, please, Madam Ombudsman.
Yes, Your Honor. The Ombudsman issued an order directing the constitution of a panel of fact-finding investigators to determine if there is possibility of bringing it to the stage of preliminary investigation. In other words, the members of the panel were directed to investigate the complaint of Mr. Bondal for plunder, among other cases.
Okay, thank you, Madam Ombudswoman. Okay. So after the creation of this panel, the special panel buckled down to work and started the investigation. And I guess that included subpoenas issued to possible witnesses and possibly subpoena to submit documents, correct?
Correct, Your Honor. The investigators confirm it.
All right. And when did the investigation terminate? What date was it terminated or finished?
Sometime in March 2015, Your Honor.
March 2015.
2015.
Okay. And in the directive issued by the Office of the Ombudsman, was the special panel required to submit an investigation report together with its recommendation?
On March 5, Your Honor, a complaint was
No, I'm
filed
not
by
referring
the
to
special
the, excuse me,
panel of...
I'm not referring to the complaint. I'm asking if there was an investigation report
Yes.
submitted by the special panel.
Yes, of course, Your Honor.
Okay, and what happened to that special, or rather the investigation report of the special panel? Was it submitted to the Office of the Ombudsman or the Deputy
yes.
Ombudsman for Luzon?
Of course, Your Honor, it was submitted to the Ombudsman.
Would you know when was that
The
investigation report submitted?
The date, Your Honor, is March 5, 2015.
March 5.
Yes, Your Honor.
And when was the complaint filed by the
March-
special panel of
Your Honor,
investigators?
if I may correct myself, it's
Okay.
March 3.
March 3. Okay, so it's not March 5. And when was the complaint filed by the special panel of investigators?
March 5, Your Honor.
And was the filing of this complaint, the March 5, 2014, 15 complaint, with the approval of the Deputy Ombudsman for Luzon or the Office of the Ombudsman itself?
The Ombudsman herself, Your Honor.
Okay. So, on March 5, 2015, what happened to this complaint? Who acted on it after it was filed?
The Ombudsman herself wants to answer, Your Honor.
Okay, please. Okay, thank you very much, the Honorable Ombudswoman.
The investigation report was submitted on March 3, 2015 by this special panel of fact-finding investigators. They filed the complaint on March 5. Now, of course, before that, the Ombudsman had already gone over the investigation report as well as the annexes thereto. Now, you were asking a while ago if the investigation report was submitted to the Deputy Ombudsman for Luzon in light of the fact that the respondent mayor is situated in Luzon. Your Honor, in cases of mayors and governors and other high officials, it is the Ombudsman which approves the investigation reports and issues orders for further investigation if warranted. Now, after the investigation report was approved and the complaint was filed and the Ombudsman went over it, the Ombudsman designated another special panel of preliminary investigators, because the fact-finding investigators cannot be the judge in the preliminary investigation and administrative adjudication.
Okay, thank you,
Thank you.
Honorable Ombudsman. The special or the panel created to now investigate the complaint was created by virtue also of a written order. It was also by virtue of a written order. And when was that issued? This particular order creating the panel of investigators to investigate the complaint filed by the Alcantara Special Panel? Sometime March 5 also, or prior
Not
to
soon
that?
after, according to the Ombudsman, Your Honor.
It was after the complaint.
Not soon after.
Not soon after. Would you say 1 day after?
We can put
Probably you
it
can
in a
submit
memorandum.
it in your memorandum. Okay. And so, the complaint involves criminal and alleged criminal and administrative offenses, right?
Yes, Your Honor.
And can you tell us if there's a difference between the procedure for the preliminary investigation for criminal offenses and the procedure for administrative adjudication, investigation, or procedure, or things like that?
Yes, Your
Is
Honor.
there a difference?
The rules are clearly indicated in Administrative Order Number 7, Your Honor, which segregates criminal investigation, the purpose of which is to find probable cause for the purpose of prosecution. Administrative investigation, Your Honor, is much, much broader, requires substantial evidence for purposes of, in certain cases, exercising disciplinary action, in other cases, exercising all the other functions of the Office of the Ombudsman.
Would you say that the procedure for administrative adjudication involves a lot of steps before it is finally decided as compared to the procedure for preliminary investigation under Rule 2?
Your Honor, under Rule 3, there are various layers of proceedings that can
Precisely.
be undergone.
And approximately, what is the length of time does it take to finish the entire procedure under Rule 3 of the Ombudsman Rules of Procedure?
I suppose, Your Honor, it would have to depend on the fact of each and every case. There are simple cases, there are complicated cases, but I can ask the Office of the Ombudsman to help me in.
Can we
In the
find
memorandum.
out if it involves a complicated matter? How long usually does it take to finish the administrative investigation?
How long?
Yes, please, if Madam Ombudsman.
It would depend on the complexity of the issues, Your Honor, and it would depend on the number of respondents. Sometimes we implead other respondents, and that will necessarily entail a little delay in the investigation of the cases. So if there are so many issues that crop up, the complexity of the issues, the complexity of the facts of the case, as well as the number of respondents, will necessarily determine the length of time that the Ombudsman would investigate the case. Like in the case of the PDAF, you'll recall that there were a lot of investigations conducted. The NBI conducted its own investigation. We conducted our own investigation, but the investigation of the NBI was not complete enough to merit the decision of the Ombudsman to segue into preliminary investigation. And that's why people were a bit impatient. But we could not do otherwise, because we cannot conduct preliminary investigation without being sure that a prima facie case exists to segue into preliminary investigation.
With regard to the PDAF cases, how long did it take the Ombudsman to finish the
I think
investigation?
we investigated the case, but once the investigation report of the NBI came in, we had to look at it, and we thought that there were some matters that had to be filled in. So I think it took us about another 6 months before we filed the case against the 3 senators.
Okay. Now, in this administrative and criminal complaint, it's a fused complaint. There are 24 respondents, and it appears that the issues here are a little complicated, involving, as it does, the construction or an infrastructure project. How long would you suppose will it take the Ombudsman to finish
It would depend on
this
the...
investigation of both the criminal and the
Yes, it would depend
administrative
on
aspects?
the cooperation of the witnesses that are called. It would depend on the availability of original documents. And that's the reason, Your Honor, why we issued a preventive suspension, because we want to preserve existing documents already. We want to gather more evidence that can stand the test of a trial court. And we cannot promise you the number of months or weeks or, no, not years. Because this is the subject of the present case is only the procurement as well as the disbursement of funds. You will recall, as everyone should take judicial notice of, that there is also a complaint for overpricing. This complaint now, that the panel of investigators did not include the complaint of overpricing in light of the fact that there is no enough evidence to determine whether or not we can segue to preliminary investigation.
So, Madam Ombudsman, with 10 counts of criminal and administrative offenses and involving, as it does, 24 respondents, would you say that the investigation of this mixed complaint of criminal and administrative offenses will take some time, something from 6 months to 1 year?
Not necessarily,
Not
but if
necessarily.
you are driving at the number of months within which a preventive suspension can be imposed,
Yes.
the law says that it should never be more than 6 months.
Okay, yes.
In other words, it could be 1 month.
Yes.
In the same manner that there have been some cases where the Supreme Court curtailed the number of months of preventive suspension in light of the fact that the ultimate purpose of gathering evidence had already been achieved.
Yes. Now, under Section 9 of Rule 3, Madam Ombudsman, it states there that pending investigation, you may issue a preventive suspension order, correct?
Rule 3 of our
Section 9 of Rule 3, yes.
of our procedure.
Rules of the
Rules of-
procedure,
okay.
yes.
We-
And it states there pending investigation.
Yes, Your Honor.
Is there a policy in the Office of the Ombudsman preliminary, a preventive suspension order can be issued, or this is at the discretion of the Office of the
When
Ombudsman?
it can be issued?
Yes.
Yes. It can be issued at the inception of the preliminary investigation.
At the inception
Yes,
of the
it can.
preliminary
It can.
investigation. I mean, when you say inception, what do you mean by that? Is it initiated by furnishing the respondents with a copy of the complaint?
Yes.
For them to
can be.
answer
It can be.
the complaint?
Because even without hearing the side of the respondents, the Ombudsman has the authority to issue preventive suspension.
Yes. And in this particular case, the preventive suspension order was issued on March 10, correct? It was
Possibly, yes.
5 days.
It should be documented.
Yes,
Yes, Your
around it's stated there, and this is 5 days from the time the
Yes.
complaint was filed with your office. Okay, and there is an allegation from the respondent that there may be some haste in the issuance of the preventive suspension order. Can you explain to us the process by which gave rise to the issuance of the preventive
Well,
suspension order?
this is what happens. Usually, the special panel of investigators progress report. They give periodic progress reports. So by the time the final investigation report comes in, the Ombudsman will already have an idea or will already understand the issues in the case. So the Ombudsman will just be waiting for the recommendation, the conclusion and the recommendation. So it would not be difficult for the Ombudsman to read the investigation report and approve or disapprove it.
So, can we safely assume that it took you 4 days from the date of the filing?
It could have
of-
even taken me just 1 day because as I told you,
okay.
there are progress reports submitted by them. And by the time the final investigation report reaches me, chances are it echoes the same reports that they had previously submitted to me, but that the recommendation would just be there, the final recommendation, the final conclusion would just be there.
So considering your familiarity with the facts of the case, including all the documentary evidences and the affidavits and sworn statements, you're saying it took you 1 day or say
No, I
March
didn't say
6th?
it took me 1 day. I said it could even take me 1 day. I
Ah.
did not say it took me 1 day.
Yes, sorry for that. But can you tell us approximately how long did it take you to
Well, it's
arrive?
documented.
What?
It's documented. You said I issued the order on March 5 or March 10 rather.
March
So,
10,
yes.
So
if we received
it's
it,
around 5 days.
if we receive, yes.
All right. Now,
You will recall that the Office of the Ombudsman gives priority to high-profile cases and
Yes.
cases that involves a great amount of money.
Yes.
1 billion is not picayune. It's a great amount of money.
yes, Madam Ombudsman. Now, under Section 24 of RA 6770 and under Section 9 of the Rule 3 of the Ombudsman Rules, there are requirements before a preventive suspension order is issued, right? There are requirements.
Yes, the evidence is strong.
The evidence of guilt is strong.
Yes, of skill is strong.
Yes.
The cases involved dishonesty, oppression, grave misconduct, or neglect in the performance of duty.
Yes.
And they could call for removal of the
Or call for
respondent,
removal.
or you want to preserve the documents that you'll probably need. Preserve and at the same time access more documents.
Yes. Now, Madam Ombudsman, what constitutes strong evidence of guilt that gave rise or served as a basis for the issuance of the preventive suspension order? And I would like to quote from the preventive suspension order, and let me read it.
Go ahead, please.
The first requisite is present in these cases, as shown by the supporting evidence attached as annexes of the complaint. These annexes include, among other things, sworn statements of alleged losing bidders and of some members of the Makati City BAC attesting to the irregularities in the subject procurement.
Yes, Your Honor.
Documents negating the purported publication of bids and disbursements, vouchers, checks, and official receipts showing disbursement of public funds by the city government.
Yes, Your Honor.
Now, it was not specified here what particular statements or documents served as basis for this order. Can you tell us what sworn statements of alleged losing bidders were considered? And we're referring to bidders. This is plural. So may we know what the sworn statement of the alleged losing bidders were considered?
Yes, Your Honor. There were purportedly 3 bidders. One was supposed to have won, and that's Hillmark. The 2 others were supposed to have participated, but one said he never ever participated. So therefore, the document reflecting the presence of 3 bidders is a falsified document. Second, one of the alleged bidders, we could not find him. The address could not be found. So,
Yes. So,
that's strong evidence.
so Madam Ombudsman, we're only talking of one alleged losing bidder, and you are probably referring to Ernesto Aspillaga? Or there's another
No, Aspillaga,
person?
I think, was not a bidder, was he?
There is, I think, a bidder. Is that... no, it's Alejandro Tenco. You may be referring to Alejandro
Tenko, that's
Tenco.
right.
Yes.
And the other is J. Bros.
J. Bros, yes. Alejandro Tenco executed an affidavit
Yes.
which is attaches Annex A-N to the complaint, right? He represents J-Bros actually.
Okay.
He is the Chief Operating Officer. And I would like to know if there is any statement in the affidavit of Mr. Tenko that herein respondent mayor has any participation or involvement?
I don't recall, Your Honor. I think
there's no mention?
I don't recall.
Okay.
I particularly recall that he says that he never participated in any bidding.
Correct. But my point of inquiry is because it pertains to the evidence of guilt that is supposed to be strong. And that this is one of the basis for issuing...
Among so many documentary and testimonial evidence, Your Honor.
Yes, but I'm going through it. And
Yes.
I'm just basing it on the ratiocination for the issuance of the preventive suspension order. So, an alleged losing bidder in the person of Alejandro Tenco, representing J Brothers, said the company never participated. And you admit that herein respondent was never mentioned in the affidavit, correct?
I said I don't recall.
You don't recall. Okay. Now, it also makes mention, this particular second paragraph of page 9, of some members of the Makati City BAC
Yes.
attesting to the irregularities in the subject
Yes.
procurement. To whom are you referring to? Who are these members?
I don't remember their names, but some of them said that there was an order allegedly given to them that they should make this X company to be the winning bidder. That's the tenor of the claim of the some of the members of the BAC.
Yes, Madam Ombudsman. And Engineer Mario Hechanova executed a sworn statement.
Yes.
And also a supplemental sworn statement stating that there are some irregularities in the procurement.
Yes,
And you are referring to this particular person who was formerly a member of the Makati BAC. Is that correct, Madam
I think so,
Ombudsman?
Your Honor.
Yes. And there is a statement there he made that he was informed by a certain engineer, I don't know, Line de la Peña, head of the Central Planning Management Office, and trusted engineer of Engineer Morales, that the projects were already earmarked to the contractor, who asked information on the quantity and specifications of the materials to be used for the project. The projects were later on awarded to contractors mentioned by Engineer de la Peña. Was this answer of Engineer Hechanova made the basis for the issuance of the preventive suspension order?
As I told you, Your Honor, there were several documents and testimonial evidence. One of the bases in issuance of the suspension order is the fact that after re-election, the mayor caused the release of payment for a transaction that violated the COA circular of 2012 because the supporting documentary evidence was not attached to the release of the payments.
There were no required supporting papers. No, I just went
And at all
over...
events, Your Honor,
yes.
in fact, you will note, I don't know if it's there, but there were some falsifications committed. For example, they would say that this invitation to bid was published in a particular newspaper.
Yes,
A check with the National Library showed that there was no such publication in that particular issue of the newspaper. A
Yes.
check with the CEO of the newspaper also showed that, and he executed affidavits, showed that there was never any request for publication of such invitation to bid.
Okay.
So those were inputted in the determination of whether or not the evidence is strong.
Okay. Now, going back to the sworn statement of Engineer Echanova, who was formerly a member of the Makati BAC and who admitted complicity in the alleged irregularities, that he made mention of several officials here. But I noticed that the name of respondent Binay Jr. does not appear in any of his sworn statements. So would you say that
That does exculpate the mayor just because Echanova?
I'm not saying that, Madam. I'm just trying to scrutinize the basis for the preventive suspension.
As I was saying, Your Honor,
Yes.
there were a lot of documentary evidence which were the basis, among
Yes.
other things, for the determination by the office of the presence of strong evidence.
Yes. You mentioned the publisher of Balita.
Yes,
That's
right.
the affidavit of Abanilla, right? And she said there was no person representing J. Bros or the other alleged bidder that caused the publication. So that is you're saying that's a basis for the falsification, correct?
Yes.
All right. Now, I went over the annexes, which serve as the basis for your preventive suspension order. And so far, all the sworn statements and affidavits have not mentioned at all the respondent Binay Jr. And I just would like to state that for a fact. Okay?
Your Honor.
However, you said a while ago that there are documents to show that respondent Binay signed and approved the disbursement vouchers for payments.
He signed notices of award, he signed back resolutions, he signed contracts, and he signed vouchers.
And you're saying this is the basis for...
Among other things.
Among other things, okay. Is there any evidence attached to the complaint that will show conspiracy?
They were.
Show conspiracy between respondent Binay Jr. with the other respondents?
Well, yes, you have to collect the evidence and can see that conspiracy is apparent.
So based on the evidence attached to the complaint, the conclusion that you derive is that there is conspiracy among the respondents, the 24 respondents.
Yes, Your Honor. There appears to be conspiracy.
And based on these statements of the alleged losing bidders, the members of the Makati BAC, and incidentally, there's also another statement made by Ernesto Apillada, who is formerly a member of the BAC. But that was before the term of respondent Binay. And he said there are always rigged procurement activities in the city government of Makati. But that's prior to the term of respondent Binay. So you're saying a consideration of all these statements serve as a basis for your preventive suspension order.
As
right?
my basis in thinking that there was strong evidence, that there was misconduct,
Right.
that there was dishonesty, oppression, or neglect in the performance of duty, and that there was a necessity to access and source all documentary evidence, the original of which are purportedly in the possession of the City Hall officials.
Strong evidence of guilt, is that more than the quantum of evidence required for a finding of probable cause for filing an information?
That's the quantum of evidence before you come up with the conclusion that there's substantial evidence to render them guilty administratively.
So, considering this is involving the administrative offenses and the preventive suspension was issued pursuant or in relation to that administrative offenses, you're saying that strong evidence of guilt is more weightier has more weight than a substantial evidence? It requires
It's
more
less,
evidence?
it's less weighty, because if it's already substantial, then we're ready to punish him if he's guilty.
I
But it's
see.
less than substantial.
Less than that's your position.
Yes.
Okay. Can we ask again?
Thank you.
Solicitor, thank you, Madam Ombudsman. Soljan Hilbay. Soljan Hilbay, are you saying that the prohibition for the courts not to issue the injunction is absolute? That there is an absolute prohibition?
No, Your Honor. In fact,
It's
we
not
referred-
absolute.
In fact, Your Honor, we referred to a residual jurisdiction on the part of the Court of Appeals to determine whether or not the Ombudsman acted outside of its jurisdiction. But that is all. That is the only extent of the inquiry of either the Supreme Court or of the Court of Appeals when looking at the validity of a preventive suspension order, as in this case.
So you admit that the Court of Appeals, assuming that it has jurisdiction, can issue a writ of injunction, right?
Only in that very limited and narrow set of cases. When
What
the
are those?
Ombudsman-
What are those?
When the Office of the
limited number-
Ombudsman issues a preventive suspension order against an impeachable public officer, a member of Congress, the judiciary, or, say, for example, a private person is subjected to investigation by the Office of the Ombudsman, and that private person is not in conspiracy with a public official. In those limited set of cases, a court can interfere. Other than outside of those limited set of cases, the Court of Appeals has to follow the statute because it is a statutory court and it has no choice other than to follow the law.
Right now, the respondents have filed their counter affidavits. Have they filed their
Yes, Your Honor.
Yes. And they're saying that the injunction will have no effect at all on the alleged delay to the proceedings before the special panel of investigators.
Yes, that is their opinion, that is their belief, Your Honor. But the statute refers to the discretion of the Office of the Ombudsman. And so the conduct of the investigation is determined by the Office of the Ombudsman, not by the respondent. It would be very strange, Your Honor, if the Office of the Ombudsman were to follow the wishes of the respondent in an investigation.
Okay. Now, would you admit that if the writ of injunction issued will not cause any delay to the investigation, then it can be issued? If it is admitted that it will not cause any delay to the investigation, then the court can issue the injunction, correct? Based on the very plain meaning of the Section 14 of RA 6770. Is that correct?
When the Office of the Ombudsman issued a preventive suspension order, Your Honor, that is her judgment
No, I'm
given by
referring to
law.
the injunction.
Yes, Your Honor.
Okay.
That the conduct of the investigation can only be done by issuing a preventive suspension order.
No,
And
but the
therefore,
issue is delay. Yeah, okay.
and therefore, any writ that impairs that investigation will delay the investigation and therefore violate the law.
Okay, that's your position. Now, the second paragraph, it says, except the Supreme Court on pure question of law. Suppose the case involves question of facts or mixed questions of law and facts. So, the Court of Appeals can assume jurisdiction. Is that correct? Just based on the explicit meaning of the provision of the second paragraph, Section 14.
I'm sorry, Your Honor. Let me.
If it does not involve pure question of law, if it involves factual questions or mixed questions of law and fact, then even the Court of Appeals has the jurisdiction to entertain any complaint relating to the decision or findings of the Ombudsman, correct?
If it is a decision, Your Honor, then yes, under Rule 43, pursuant to Fabian. If it is an interlocutory order, Your Honor, yes, under BP 129, but no injunction. It is as clear as that, Your Honor.
But you said a while ago that on the assumption that it will not delay the proceedings and the investigation, the first paragraph of Section 14 says it can be issued. Isn't that?
No, absolutely not, Your Honor.
Okay, that's your position. All right. Thank you, Mr. Solicitor General.
Thank you, Justice
Justice
Velasco.
Hardileza.
Madam Chief Justice, may I yield to Justice Bersamin? And I apologize, I did not see that Justice Bersamin wanted to ask questions. I only request that after all of the justices are through, can I have a chance to ask one last
We
question?
will allow you, and we don't necessarily need to limit it to only one, Justice Hardileza. So, Justice Bersamin?
I was already reluctant to ask because Justice Velasco almost covered everything. This is just a curiosity. Is it your position that only the Supreme Court may take proper cognizance of an application for a remedy against the Ombudsman?
In this case, Your Honor, in the absence of a remedy provided by the Court of Appeals, then the only remedy is by petition for certiorari under Rule 65 before the Supreme Court.
Okay. Under our scheme of hierarchies or our choice of courts where you may bring a Rule 65 petition under Section 4 of Rule 65, when it is a judge, tribunal, or office, a single office, not a collegial, the RTC is given, the chosen court is the RTC. You remember Section 4?
Yes, Your Honor.
And when it is a board or a collegial body, the proper court is the Court of Appeals or the Supreme Court in the scheme of values or hierarchy of courts.
Yes, Your Honor.
Okay. So if this, the Ombudsman is a singular official, may you deny the RTC under this Section 4 the authority to review or to have a go at Rule 65?
Your Honor, if the goal of a particular respondent, such as private respondent in this case, is to obtain a writ of injunction, whether or not a TRO or a writ of preliminary injunction, Congress has already spoken. Because all these courts are statutory courts, Congress has full control over causes of action, over remedies. And therefore, the rules of court presume the existence of a jurisdiction on the part of a court. In the case of the Supreme Court, the Congress has no authority over them, over it, and therefore, whether original or in aid of its original jurisdiction, there's nothing that Congress can do. But in this particular case, if the goal is to secure a writ of preliminary injunction or a TRO, Congress has already spoken. You cannot get it from the Court of Appeals or the RTC unless the investigation of the Ombudsman is prima facie out of its jurisdiction. That is our position, Your Honor.
Yeah, but there is that qualifying phrase there, to delay. You are speaking as if you forgot about that phrase, to delay.
Thank you, Your Honor. As I said earlier, an injunction, by its nature, delays a proceeding. As in fact, in this case, in the judgment of the Office of the Ombudsman, the issuance of the TRO as well as the WPI are meant to delay an investigation. It is the Office of the Ombudsman that determines whether or not a delay is caused by the issuance.
How does a stoppage of a preventive suspension order delay the investigation that is being conducted by a very independent ombudsman?
Yes, thank you, Your Honor. When an investigation can be conducted by the Office of the Ombudsman with or without a preventive suspension. And so when the Office of the Ombudsman issues a preventive suspension order in its investigation, that by itself is a judgment on her part that the most expeditious, credible way to conduct an investigation is by removing temporarily the public official concerned.
My understanding from your contentions today is that you do not deny at all to the Supreme Court the power to issue anything, writ of injunction or review of a decision of the Ombudsman. Is my impression correct?
That is as it should be, Your Honor, because Congress has no authority to touch the original jurisdiction of the Supreme Court under Article 8, Section 5, as well as the authority of the Supreme Court to aid it in the exercise of that original jurisdiction.
Okay, let me focus your attention to the second paragraph of Section 14. That word there, any appeal, it's not an issue here, I believe.
Yes.
But let me ask you this, is Fabian not going to be a precedent for questioning the authority that this particular paragraph of Section 14?
Thank you, Your Honor.
Considering that the Supreme Court seems not to have been consulted priorly?
Thank you, Your Honor. Allow me to clarify the full extent of our position. Fabian, Your Honor, refers to Section 27 with respect to appeals from administrative decisions of the Office of the Ombudsman. Section 27 purported to confer appellate jurisdiction on the Supreme Court via Rule 45. Given that the court was not, the advice and consent of the court was not secured by Congress, under Article 6, Section 30, Section 27 will have to fall as the court did in Fabian. And therefore, with respect to decisions of the Office of the Ombudsman, the rule is you go to the Court of Appeals via Rule 43. Right. With respect to interlocutory orders, Your Honor, of the Office of the Ombudsman, the Supreme Court has absolute authority to assume jurisdiction under Rule 65 because of its original jurisdiction for certiorari under Article 8, Section 5(1). With respect to all other courts, given that they are statutory courts, it is the Congress that can determine whether or not such courts will have certiorari jurisdiction. Under BP 129, the Court of Appeals has original jurisdiction for certiorari and prohibition. That is a given. And so the question in this case is, can Congress, by way of statute, limit the authority of the Court of Appeals to such original jurisdiction, then deny entirely or almost entirely its power to issue an ancillary remedy or provisional remedy such as a TRO or a writ of preliminary injunction? The answer, Your Honor, is yes.
Let me hypothesize. Supposing it was an issue here, and that issue that I was referring to is that the Supreme Court's appellate jurisdiction is being questioned as far as that second paragraph is concerned. Does that not result into a void or a vacuum? No court would have any more jurisdiction, appellate jurisdiction in relation to the Ombudsman?
Your Honor,
is that your point?
No, Your Honor. Appellate jurisdiction with respect to decisions of the Office of the Ombudsman under Fabian is with the Court of Appeals under Rule 43. Certiorari is
just
not...
to be clear, just excuse me, because this is a paragraph that refers to decisions or findings of the Ombudsman.
Yes, Your Honor.
And that is followed by that phrase, except the Supreme Court.
Yes, Your Honor.
Now it seems to be saying here that it is the Supreme Court that would have exclusive appellate jurisdiction on pure questions of law.
Your Honor, we have to read...
If there was an issue about this in the mold of Fabian,
Yes.
would you insist that no other court can review the Ombudsman anymore?
No, Your Honor. The language of Fabian was a jurisdiction conferring language, meaning that if you look at Section 27...
Yeah, we are aware of Fabian and
Your
all
Honor,
the corners of Fabian.
Yes.
So we don't need to go to that because I think we need to hear also the other side.
Yes, Your Honor.
I am just curious about your position regarding this particular matter here of limiting the appeal to pure question of law to the Supreme Court. Of course, you know that in Rule 43, you can have a question of law, a question of fact, or a mixed question of fact and law.
Yes, Your Honor.
Now, is that not going to weaken the second paragraph as an unconstitutional enactment of the Congress?
No. Again, no, Your Honor. I go back to Fabian. If it is a decision of the Ombudsman. Then following Fabian, the appeal is with respect to the Court of Appeals under Rule 43. When it comes to interlocutory orders, which can be corrected by a petition for certiorari under Rule 65, it is before the Supreme Court. But if you go to the Court of Appeals, as is usually done in these cases, our position, Your Honor, is that while the Court of Appeals has original jurisdiction for petitions for certiorari and therefore determine whether or not grave abuse of discretion was committed, the Court of Appeals, by clear statutory language, has been expressly denied the authority to issue a TRO or a writ of preliminary injunction. This is the same rule with respect to national infrastructure projects, Your Honor. This is not novel, this is not strange.
No, but there is a policy there on the part of Congress in respect of infrastructure projects.
Yes.
In order to prevent the lower courts from issuing left and right injunctive writs.
Yes, Your
That's the
Honor.
mischief that that law was intended to cure or to prevent. But here I don't see the same, the analogy that you are raising now.
If I may, Your Honor.
Anyway, I will like you to state for the Ombudsman in a memorandum later
Yes,
on
Your Honor.
if dealing with this issue of whether the Court of Appeals could issue a writ of injunction or a TRO when it is an appeal that is brought there from the findings in an administrative case of the Ombudsman. Because my understanding up to now, and I don't think it has been changed at all by the Supreme Court, is that injunction as a provisional relief is part and parcel of a case where there is a cause of action that would involve enjoining an act of the defendant.
If
I will like you to have that in your memorandum.
If I may give you a preview of the answer, Your Honor, if there is already a finding by the Ombudsman in an administrative case, that means that the investigation is already over. And because the investigation is already over, that investigation is no longer susceptible to a TRO or a WPI for purposes of delaying the investigation.
I think I will not disagree with you on that, but this is a case where Mayor Binay went to the Court of Appeals on certiorari, Rule 65.
Yes, Your Honor.
And he did not like the preventive suspension order to be applied to him. And he claimed that there was grave abuse of discretion. And I don't think you will disagree if I say that the Ombudsman must follow some parameters in issuing this preventive suspension order pursuant to Section 27.
Of course.
That's why it is only a Rule 65 petition that could have been brought by Mayor Binay, not any other remedy.
Exactly, Your Honor. And in fact, we agree. The only question here, Your Honor, and the only question in this case is that regardless of whether or not the Court of Appeals has jurisdiction over the petition for certiorari, whether or not they could have issued a TRO or the WPI. And the answer, Your Honor, is clear because Section 14 says so.
Okay, thank you, Chief. I'm done.
Deleza.
Thank you, Mr. Justice Bersamin.
Mr. Soljan, just some clarifications. Suppose the respondent went directly to this court, meaning suppose the respondent filing the same Rule 65 petition, filed it with this court and not with the Court of Appeals. Because suppose they did the same research that you did, and they realized that, yes, maybe after all, and they anticipate what your position is, that indeed the Court of Appeals has been stripped of its jurisdiction. So, in that hypothetical, the petitioner goes to us straight on a Rule 65, exactly the same petition. So get the Court of Appeals out of the equation. My question is, just like Justice Perez, it bothers me that you made a statement that injunction per se delays. Therefore, are you saying that if Respondent Binay went directly to this court, is the same preventive suspension order issued by the Honorable Ombudsman beyond the reach of this court in a Rule 65 proceeding?
The answer, Your Honor, is no. As I have previously stated, Section 14 does not touch the original jurisdiction of this honorable court under Article 8.
Thank you. Now, because I'm still confused, you seem to be saying this court has jurisdiction because it's original, fine.
Yes.
But you seem to be saying that the jurisdiction of this court is limited to what you call residual jurisdiction.
No, Your Honor.
Meaning, if the respondent is an impeachable officer or is a member of Congress or a member of the judiciary, then even this court, then this court should throw out the petition.
No, Your Honor. Again, allow me to clarify.
Because I think let me pinpoint exactly what is your position. Since the respondent is not, since the petitioner in this court is not a member of Congress, is not an impeachable officer, therefore, do we have Rule 65 jurisdiction over the petitioner?
Yes, Your Honor.
Yes. And do the finding of the Honorable Ombudsman, is that conclusive on us?
No, Your Honor.
Okay. If it is not conclusive on us, then we can exercise a Rule 65 review based
Yes, Your
on
Honor.
grave abuse of discretion.
Yes, Your Honor.
So just for clarity, it is not conclusive on this
Yes,
court.
Your Honor.
And therefore, your statement that an injunction as the one issued by the Honorable Ombudsman is per se delay, that seemed to make conclusive what her finding is.
Okay. As we stated, Your Honor, in our short paper, the injunction equals delay applies to the Court of Appeals because it is conclusive upon the Court of Appeals.
But that's why I am saying, just for clarity, get the Court of Appeals.
Yes, sir.
You are before this court. Binay chose to go because they accept your argument about apportionment of courts, and you have stripped, and 14 has stripped. Imagine, you're now before this court.
Yes,
The
Your
question is very simple. Is the finding of the Honorable Ombudsman binding and conclusive in this court in all respects? Because it seems to me if you say yes, then we have an issue. You are saying the finding is beyond the reach of judicial review. So I need to fix where is really your position.
The finding of the Ombudsman, Your Honor, is subject to a high level of deference, but not conclusive upon the Supreme Court, given that RA 6770 cannot touch the constitutional authority of this honorable court.
So no, so that thank you, that clarifies it. It is not conclusive.
Not conclusive, Your Honor.
It is subject to Rule 65 review. Okay?
Yes, Your
now,
Honor.
let me go now to some of the statements that you have made so that you will guide this court. And I think, having considered that it is not beyond judicial review, the next question which we are interested is, what is the level of review in your mind that this court can do? Now, on page 11 of you're saying that the Congress, consistent with the independence of the Ombudsman and the goal of avoiding unnecessary entanglement of courts into the business of the Ombudsman, okay? And I highlight independence and entanglement of courts into the business of the Ombudsman. Now, I go now to page 14. You argue further that with reference to the preventive suspension order of the Ombudsman, the legislative intent was to, and I quote, commit full discretionary authority to the Ombudsman's findings, and thus, and I quote, thus immunize it from injunctive suits. And then you quoted Section 24, and then you say this is the language of discretion. It evinces, and I quote, a textual commitment to the Ombudsman of full discretionary authority to preventively suspend. You remember, those are your words. Now, my question is, words like entanglement, textual commitment, recall to mind which American case, Baker versus Carr?
Yes, Your Honor.
So, when you say a textually demonstrable commitment of an authority to either a branch of government or to an officer, in Baker versus Carr, the sacramental words meant there is a political question.
Yes, sir.
And are you now by any means suggesting that since, is that the test that you're suggesting, that because you keep quoting textually, demonstrable commitment, therefore, whilst we have Rule 65 jurisdiction, is this one of the instances where, as Father Berna says, there may be still instances where the political question doctrine may be alive? Are you invoking, in effect, a variation of the political question doctrine?
Your Honor, if you look at page 14, Your Honor, the section that you quoted refers to the Court of Appeals. In our short paper, we have sought as clearly as we can to distinguish between the Supreme Court and the Court of Appeals.
That is why I am now with the Supreme Court. That's why I thought I said, let's forget the Court of Appeals.
Yes.
Section 24 applies to the Court of applies to the Supreme Court. So please don't go anymore to the Court of Appeals. The question is very simple. You are arguing full discretionary authority based on a textually demonstrable commitment of a discretion to the Ombudsman, protector of the people, independent under the Constitution. The question is very simple. Are you saying that therefore the findings of the Ombudsman are beyond reach of Rule 65 because it is in effect or is a variant of a political question?
Okay. Your Honor, the answer is rather straightforward. With respect to the Supreme Court, no, because this is just a statute. With
That
respect,
stops it because with respect, even if you filed directly with us, then the findings of the Honorable Ombudsman are within reach of Rule 65, if you filed directly with us. Now, the next line of questions, so we have to be brief, is assuming we have jurisdiction because you are not invoking political questions, I ask you now, what is the degree of deference that we owe the Honorable Ombudsman? You keep saying high degree. So, what exactly is it, high or highest degree? Now, I am pointing out, are you by any means trying to suggest that just like in the area of freedom of speech or the First Amendment, the acts of the Ombudsman are entitled to the strictest scrutiny from this court?
Your Honor,
or a stricter, or a not only stricter, but it seems to me from the way you talk, a strictest scrutiny from this court. And if you can put in a scale of 1 to 10, 1 to 10, 1 is the lowest differential scrutiny up to 10, where will you place the ability or the power of this court to examine whether or not the act of the Honorable Ombudsman constitutes grave abuse of discretion?
it's really very difficult to assign numbers, but if I may use, Your Honor, the language of the court itself, it translates to a policy of non-interference. Simply that. That is the language of a court in a decision called Karaan versus Ombudsman, June 21, 2004.
That's exactly what does, because our problem is the standard is substantial evidence. And there is nobody is disputing that. But when we review now, help us. The Ombudsman is independent, we recognize it, is a protector of the people, and you're faced with a particular case. She says there's substantial evidence. What kind of review? Now, the differential is not helpful in the sense that in some cases this court will reverse. In some cases this court will affirm. So help us. What exactly is differential means? That's why I'm now going to the First Amendment to freedom of speech. Are you saying strict scrutiny, or even stricter scrutiny, or even strictest scrutiny? And that's why I have the scale. Are you saying in a scale of 1 to 10, 9 or 9.5, or almost 9, almost 10?
Your Honor, no amount of language that I use, I think, can translate into a mathematical form this policy of non-interference. Because you are the members of the Honorable Court, it rests upon you, Your Honor, to translate this policy of non-interference. If I were to suggest anything, I would simply say, given the constitutional stature of the Office of the Ombudsman, then you would have to respect, in the large number of cases, right, the exercise of that particular discretion without taking away from the Honorable Court its power to exercise certiorari jurisdiction in cases where you find grave abuse of discretion amounting to lack or excess of jurisdiction.
Thank you, Mr. Soldier.
Thank you, Mr. Justice.
Justice Carpio.
Mr. Solicitor General, let's go to Section 13.3, Article 11 of the Constitution. It says, the Office of the Ombudsman shall have the following powers, functions, and duties. Direct the officer concerned to take appropriate action against a public official or employee at fault and recommend his removal, suspension, demotion, fine, censure, or prosecution, and ensure compliance therewith. In a long line of cases, we already said, this power of the Ombudsman is a direct power. The superior of the person being suspended cannot refuse. He must remove or suspend. Follow the instruction of the Ombudsman. So the power to suspend...
If I may, Your Honor, the language of the Supreme Court, the Constitution itself says recommend.
Yes. What
And
did we say?
recommendation cannot be, non-discretionary.
But what did the Supreme Court say about that power? In several cases, we said the Ombudsman can suspend or remove directly even if
Yes,
the
of
public
course.
officer refuses.
That is a statutory power of the Office of the Ombudsman, Your Honor.
And
But
we-
if we're talking about the Constitution only says...
No, we
recommend.
already said that because of the vast powers given by the Constitution, this is not merely directory, it is mandatory. The power to remove or suspend is a constitutional power. Now-
Your Honor, if I may, if we look at the Constitution and the powers of the Ombudsman under the Constitution, the Ombudsman doesn't have the power to remove. And I don't see in...
Ledesma, we have several cases already.
Your Honor, I'm referring to the constitutional power of the
Yes,
Office
but
of
we
the
have
Ombudsman.
interpreted that to mean as a mandatory power. Do you agree?
Okay, yes, Your Honor.
Or you want to reverse us?
I will
it is
have
a
to look at the cases, Your Honor.
Okay. Now, believe me, we already ruled that is a mandatory power of the Supreme Court. So the power of the Ombudsman to suspend is a constitutional power, correct? Following our interpretation.
Yes, Your Honor.
Okay. If it is a constitutional power, can Congress empower a statutory court to stop the Ombudsman from exercising its constitutional power?
Well, I suppose no, Your Honor.
No. Okay, thank you, Counsel.
May May I just ask the Ombudsman to please approach the podium. You had earlier stated that there are many pieces of evidence that would not be easily within your reach unless there is a preventive suspension order. Did I get your statement correct?
Yes, Your Honor, there are pieces of evidence, the original of which are in the custody of the municipal officials, and we want to preserve this evidence.
Now, until the preventive suspension order is served, who signs the payroll for the officials of the city of Makati?
I'm sorry, Your Honor. If my reading of the newspaper reports is correct, I think the head of the government is the one who signs the payroll, unless he delegates it to someone.
Is it part of the implied statements that you had been making that you needed preventive suspension in order to allow the investigation to proceed unimpeded?
Yes, Your Honor.
Now, assuming that the court rules that the Court of Appeals has jurisdiction to review the preventive suspension order of the Ombudsman, as well as to issue the writ of preliminary injunction, which, because we have accepted your supplemental petition for certiorari, is now before this court. Can we move forward and also review the finding of the Court of Appeals that there is no strong evidence of guilt?
The Court of Appeals came out with two grounds for issuing the writ of preliminary injunction. They said we have not discharged the burden of showing that there's strong evidence, and second, the condemnation doctrine. And we refuted that there's strong evidence, and the condemnation doctrine, assuming arguendo that it applies in the case of the respondent mayor, there is documentary evidence to show that post-re-election, he caused the release of payments for a design architect or whatever, MANA, without complying with the 2012 circular of the COA requiring the submission of documentary requirements before causing the release of payments.
Thank you. Can you please outline in your memorandum and explain these points further?
We will do that, Your Honor.
There being no further questions from anyone, there is a motion here that we suspend the hearing and call it for next Tuesday. So we will reconvene on April 21, 2 p.m., also at the same venue, in order to hear the arguments of respondent. If there is no further matter at hand, this session is hereby adjourned.